Thank you.
Good afternoon, Justice Bloom.
Good day, Chief Justice.
How are you?
I can't complain. Thank you very much under the circumstances. I hope you're well.
Indeed, yeah, I am as well as can be. First, let me apologize for keeping you waiting. The meeting of the Commission earlier this morning took longer than we'd all anticipated. We had difficult issues to discuss. So do apologize for that.
No need to apologize. Thank you.
Thank you very much. Are you ready?
As can be. Thank you very much.
Okay. Well, luckily for you, we have interviewed you previously, not so?
Yes.
So you're not a complete stranger, and we likely won't have many questions for you, but I can't speak for my colleagues. I'll speak for myself. Would you mind just giving us a brief summary of who you are, your academic qualifications, and your work experience, just briefly?
Thank you. I was born in the Free State, Kroonstad. Went to school there until standard 6 at the time. We then had to troop off to Bloemfontein because Bloemfontein was the only high school in the entire Free State. But I matriculated in Uitenhage, Kariga now, and after that I went to the University of the Western Cape, where I obtained a BA degree and then a teacher's diploma, went back to Kroonstad to teach for 1 year, and then went to Rhodes in Makanda to study there, and I've been there since. After obtaining the degree, I did articles of clerkship. I was admitted as an attorney, practiced there for 6 years, and then went to the bar. And I practiced at the bar for 19 years and was appointed in 2015 as a judge of the Eastern Cape Division of the High Court.
And you were silk at the time of your appointment, not
yes,
so?
5 years. Before the appointment, I practiced as a silk.
Yeah. I may have asked you this question before. Why did you leave teaching? Which knowing you suits your temperament so much?
Well, 1982 was not the easiest of years in the country. And I used to hang out with a number of friends, and the one day, one of my friends went to a march. And it was at the march where the police got hold of him and he was severely assaulted. And he joined up with us, but he was exceptionally quiet. And we ultimately found out why he was so quiet. At the time, I was a teacher and everyone looked up to me for guidance. And I felt very helpless because I didn't know the law. I then decided, well, there was an attempt to do law when I was at the University of the Western Cape, but I did not pursue my studies there. With this incident that happened, I decided to go back and study law. The aim was to become a criminal lawyer and a criminal lawyer only. And I did less than 5% of criminal law in my practice. So that's why I left teaching, a profession I do still respect, and I would not have given it up had it not been for that incident.
How long have you been a judge of the High Court?
I was appointed 1 June 2015, so that makes it short of 11 years. I've completed 10 years. So end of May, I will have been a judge for 11 years.
And how long do you still have to serve before retirement?
Just short of 4 years, if appointed.
Right. And you have acted at the Supreme Court of Appeal in
Yes.
recent times. You're there now, not so?
I'm not at,
Or not at the moment?
At the moment, the last time I acted was in November last year, and that was my fourth acting stint in the Supreme Court of Appeal.
And how long in all have you acted in that court?
I beg your pardon?
How long have you acted at the SCA?
I have acted for 4 terms
All right.
in the Supreme Court of Appeal.
And you had an opportunity to write judgments for the court?
Yes, during my stay, I was meant to have written 8 judgments, but I wrote 10.
That's a lot.
Because in 2 of them, I dissented. So that my dissent attracted 2 more judgments.
All right.
Yes.
And just remind us, how many judgments have you penned in all, an estimate will do?
I said the last time when I was here, I would not be able to give you an exact number, but it is in excess of 200 judgments that I have written.
Your questionnaire indicates parted matters, 3 parted matters. What's the status of those cases?
The criminal matters I
Yes.
have concluded. The civil matter I have, well, there are 2 parts to it. The first one is I have, in respect of one of the defendants, given absolution from the instance, and the plaintiff is not happy and asked for leave, and I granted leave to appeal. And the other aspect, I had to make a ruling on the admissibility of evidence, certain evidence, and after that, because the plaintiff is about to close its case in respect of that plaintiff. So that's where we are, but the plaintiff is about to close its case in that way. So the 2 criminal matters have been concluded, and we reaching the end of the civil matter.
And you listed only one reserved judgment from late
Yes.
November at the SCA.
Yes. I was hoping to say to you by the time I get here that that judgment had been delivered. Unfortunately, I cannot say that. The judgment is in circulation. I am a co-scribe in the matter. I had given my portion of the judgment to my colleague. She then did her portion, and we looked at the entire judgment, and we then sent it out. We circulated the judgment. We have already received feedback from 2 of the other judges. There's one who is making, but he has apologized for the fact that he hasn't come back. He was just busy with other judgments.
All right. So between your last appearance here and now, is there anything worthy of our attention that you have done? An additional judgment or anything at all that you might want to bring to our attention? I know it's been a short period of time.
Chief Justice, that's too wide. I prefer to be asked questions rather than volunteer. I have no idea what it is that I should mention.
No, I mean something you'd want to add to your CV. That would, a new addition to your CV.
I'm a very conservative person, so the answer is no.
Okay.
There's nothing to add. Thank you very much.
No, it was not so long ago, so that's perfectly understandable. Thank you, Judge Blom.
Thank you.
I'll hand over to the head of the court you wish to join, President Mulemela. Press.
Thank you very much, CJ. Good afternoon. Judge
Morning, President.
Bloom, how are you?
I can't complain, and you?
I'm fine, thank you. I don't have many questions for you. We do have your transcript from the last interview in front of us. I will just follow up on your response to a question posed by the Chief Justice, because as you know, reserved judgments are a concern, not only in respect of the SCA, but in respect of all the courts. And I just want a further explanation from you as to why it has taken this long for the judgment to still be in a reserved judgment status. You left the courts in November. So December, January, February, March, it's now April, meaning the 3 months standard period has now passed. If I may ask, when did you circulate the judgment?
When you say you mean the joint judgment or my portion of the judgment?
Your portion of the judgment.
That must have been in the second month after the hearing of the appeal.
Yes, and when was the joint judgment circulated?
President, I must just mention that at the post-hearing conference, my co-scribe indicated that she had other matters and she was working on them. So she delivered approximately, I would say, it was just short of the 3 months after the hearing of the appeal.
Okay. So from your answer, it would seem that the delay is not attributable to yourself.
I don't want to throw others under the bus, but to answer your question, yes, I submitted early.
All right, thank you very much. That was just a follow-up to the CJ's question. My question is, why do you think collegiality is important at the Supreme Court of Appeal? Part of the answer would be that we don't, not a single matter can be decided by one judge on his or her own. So we always sit in a panel. And my question is, why do you think collegiality is integral to the functioning of the SCA?
For precisely that reason, President, you do not work alone in the SCA. You work with at least 4 other people. Mm-hmm. And you need to be collegial, again, with those you work with, whether it be in court or out of court. And that has been my experience at the Supreme Court of Appeal. People are very collegial.
Yes. And you have not had any issues of collegiality raised against yourself?
Not that I am aware of, and I have not experienced any difficulty with other judges.
Yes, I can confirm that I too have not received any complaints about you in terms of collegiality. Thank you, CJ.
Thank you, President. JP Tlaletsi.
Good day.
Good day,
Yes.
JP.
Yeah, just a short one. Lately, the judiciary is in news for the wrong reasons. Now, the last time you signed your questionnaire was on the 4th day of December. 2025. Between then and now, are there any circumstances that you think might, your appointment might embarrass the judiciary or this body? There are so many allegations flying around. Are you aware of any such circumstances that can embarrass us if you were to be recommended for appointment?
No, JP, you said it's a short question, and the short answer to your short question is no. I can't think of any reason.
Okay, I'm not embarrassed. Thank you.
Thank you.
Commissioner Matolo Shebo.
Thank you, Chief Justice. Good morning, Judge Bloom.
Good morning, Commissioner.
Okay, mine
Afternoon.
mine is also short. You know, you have been here before,
Yes.
and we are interviewing colleagues. I mean, your colleagues. I just want to find out from you, what do you think you have that will put you ahead of the other interviewees, because they are all strong, and I see that all the legal bodies are supporting you. What do you think stands out for you?
Well, I bring with me 2 years of articles. Many people write over that period. I think it's a very important period because that's where the practical side of law becomes alive. I bring with me 6 years of being an attorney, and I bring with me 19 years as a practicing advocate, and then I bring 10 years of experience as a judge. And then what we also need to remember is I come from the Eastern Cape, where we do all sorts of work, from customary law to maritime law. I am stationed in Makanda, but we also do work in the other stations. So one day I arrived in Gqeberha, only to realize there was a huge maritime matter waiting for me. I've not been exposed to maritime ever. Well, when I was with the Legal Resources Centre as an attorney, we used to arrest ships in Gqeberha, but the papers were not drafted by us. They were drafted by the Cape Town office, and they would miss a ship, and then they would ask us to have it arrested. So that was the extent of my maritime experience when I was as an attorney, not at the bar. But as a judge, I was exposed to maritime, the matter I've just referred you to now. Then customary law is, I understand from some of my colleagues that these seldom get past them in other divisions. And that's almost second nature in the Eastern Cape, where we do a lot of customary law as a judge. So I come with my practical experience as a practitioner as well as a judge, and with that, the variety of work that I have been doing both as a practitioner and as a judge.
Thank you.
Good afternoon, Judge
Good day, Commissioner.
Bloom. Yes, I do understand you were here in October, but I have been assigned to inquire from the candidates whether they are aware that there is an anti-sexual harassment policy. Are you aware of that?
Yes.
And have you acclimatized yourself with it?
We were required to do so because there was a follow-up seminar that was held in the Eastern Cape.
And you can confirm that you have no problem with its implementation in its current form?
The short answer is no, but I think it's work in progress. It's a new document that was signed by the Chief Justice in August of last year, and I think it's work in progress. So for now, the answer is I don't have a difficulty with the content of the policy.
Thank you.
Thank you, Commissioner. Any further questions? Commissioner Moimang?
Thank you. Oh, thank you, CJ. Good afternoon, Judge Bloom.
Good afternoon, Commissioner.
Just one question from my side in relation to the judgment that you have cited as your contribution, as part of your contribution to jurisprudence, as Zeal Health Innovations. Make me understand as to why, when a contract, an unlawful contract, has been set aside, should the beneficiary of an unlawful contract be entitled to payment of any amount that is related to that unlawful contract.
Thank you. Commissioner, I think verbatim you asked that question the last time, and I'm going to try to respond verbatim to your question. There was a difficulty with the contract. The department had a certain budget and the contract went over the budget. And the law says you can't do that. So the High Court set aside the contract on that basis. And there was an appeal against that. We dismissed the appeal, but we said that the High Court should have gone further, and the High Court should have, there should have been a just and equitable relief, and that relief was because the service provider had delivered services, albeit in terms of the invalid contract. The service provider had to be paid, and that was our response. You will see that we did not tell the High Court what should be paid. It was for that court to decide. So we thought in terms of Section 172 of the Constitution, there should be a just and equitable remedy to the service provider who had delivered services, as I say, albeit in terms of an invalid contract.
Thank you, Judge Blue. Thank you, CJ.
No further questions. All right, just to round off your CV, Judge Bloom, because I know this part of what you've done during your career as a lawyer is important to you. You were a member of NADEL from 1987. I imagine that's when you started practicing until your appointment as a judge.
There was excitement in the office in which I did my articles. My mentor, my principal, took me to the launch of NADEL, and I was a member until I became a judge when I resigned.
And you were also involved in the business of the Eastern Cape Society of Advocates and the Eastern Cape the Grahamstown Bar, of which you were chairperson, respectively.
Yes.
And you also were involved with the Advocates for Transformation between 2006 and 2015, and you chaired the Makana branch?
Yes, that is correct.
All right. Thank you very much. It does not appear that there are any further questions for you, so unless there's anything you wish to raise with the Commission, you're excused.
I thought I was going to have a laugh with Commissioner Pillay because Advocates for Transformation once again got it wrong insofar as the figures are concerned at the Supreme Court of Appeal. There are more females than males at the Supreme Court of Appeal. I'm sure the President would vouch for that.
Indeed, you're absolutely right. Thank you very much, Justice Blum. You're excused.
Thank you very much, Ombudsman.
Good afternoon, Judge Celi.
Good afternoon, Chief Justice and the other members of the panel.
How are you?
I'm good under the circumstances.
We are running behind schedule and we do apologize for keeping you waiting.
No problem.
Is this your first time before the JSC, not so well, for a vacancy in the Supreme Court of Appeal?
Yes, Chief Justice.
All right. You hold 2 law degrees, a BUris and LLB from UKZN.
That is correct.
Is it Ngoye or the former University of Natal?
Ngoye.
Ngoye, all right. And you started out as a volunteer teacher.
That is correct, Chief Justice.
But only for 6 months.
That is correct, Chief Justice.
How did you find that experience? You then joined the Department of Justice and started as a court interpreter, and then worked your way through the prosecution, where you became a senior state advocate, and then a magistrate.
That is correct.
How long were you in the Department of Justice? I see that you were a magistrate for what?
For 9 years.
9 years.
That's right, yes.
And in prosecution, 2, 3,
9 years.
5, another about 9 years.
Another 9 years,
Yeah,
yes.
all right. Yeah. And then you were you started acting as a judge between 2009, had various acting stints,
Yes.
until your permanent appointment in 2014
That is correct.
in the division where you still are to date.
That is correct.
Okay. You acted as a deputy judge president in your division for
Yes,
a spell,
Yes.
a term.
Yes, for a term, yes, correct, Chief Justice.
All right. How did you find that that stint,
I
the hot
enjoyed-
seat in the leadership?
In the leadership, I commanded the respect of my colleagues. I really enjoyed it.
And you acted as a judge at the Supreme Court of Appeal from October 2024 until November 2025, or was there a break? Your questionnaire does not make it quite clear.
Yes, there was a break, but actually it is 3 terms.
3 terms, unbroken. Broken, okay.
Yes.
So the first stint was between October and November.
That is correct. Chief
All right.
Justice.
And then the second stint was June to November last year.
That is correct.
Okay. And you are back in your division at the moment.
Yes, I'm back in my division.
How many judgments would you say you've written in all? Both as a magistrate and as a judge?
I'm unable to count. but
We don't need an accurate figure. A rough estimate will do.
It's way over 200.
So you've been quite prolific.
Yes.
And one would imagine that you've written across the spectrum of legal issues.
That is correct, Chief Justice.
KZN also does work that we don't find in other divisions, maritime law cases.
Yes, we do. And I think I shot myself in the foot by not mentioning one of the judgments I wrote, which is a shipping judgment.
I was going to ask if you've not had occasion to sit in a shipping law matter, and if you've not written a judgment in that niche area
Yes,
that should not be niche at all.
I did, actually. I did a couple of applications for arrests of ships at fundandum jurisdictionem, and then, but ultimately I wrote a judgment in a trial matter which involved a collision at sea at Richards Bay, yes. I wrote a judgment.
Do you have the particulars of that case? It's fine if you don't.
I'll make it available, Chief Justice, if I have to do that. But I know that it's on my laptop. Laptop. I forgot my laptop this time. Okay. But it is on my laptop.
How long ago was this?
It was in 2022.
Oh, so it's been a while. Was it taken in appeal? Is it still good law?
There was an application for leave to appeal, which I refused. I don't know what step they took thereafter, but they brought an application for leave to appeal, which I refused.
And it has not been brought to your attention that they took it further and...
no, it has not.
It was further ventilated. All right. You mentioned 2 reserve judgments.
Yes.
I'm not sure if this would have been from the SCA, the Board of Sheriffs, Sabuka.
Yes, it is in the SCA. Chief
Or
Justice.
both actually should be at the SCA.
Both of them, yes, yeah.
All right. What is the status of those judgments?
The board for sheriffs versus Sibuga, that judgment has not been delivered as yet. But I circulated the judgment, the draft judgment, the first draft on 14 October 2025. 3 members of the panel concurred in my judgment. 1 member undertook to dissent, anticipating the point that the member who wanted to dissent was going to take. I therefore prepared another draft judgment, that is now the second draft, to deal with that point, and I circulated the second draft on 24 November 2025. The dissenting member of the panel subsequently sent her judgment on 18 January 2026. The matter is presently with the presider. I made a couple of calls to the presider, trying to establish what the delay, what the cause of the delay is, but she had always indicated that she's going to attend to it. Eventually, I called the deputy president in February because I was concerned about the fact that I'm going to be grilled about this here during the course of my interview. So I called the deputy president in February and I explained to him what about the delay in this matter. He sort of allayed my fears and stated that once the judgment has been circulated, it is completely out of control. There's nothing you can do about it. But as things stand, as I indicate, it is this matter is with the presider.
Yes. Oh, is there more?
Yeah, that is all with regards to this matter. I want to move on to the next one, which is Sambo versus RAF. Sambo versus RAF, I circulated the first draft on 12 February 2026. Two members of the panel, including the presider, concurred in my judgment and made inputs. I was in contact with the other two members of the panel who were swamped with work at the time. But eventually I circulated a clean copy for read-through conference, which took place on Friday last week, which is the 10th of April. We were unable to finalize the read-through and we deferred it to either tomorrow or Wednesday. But the judgment is definitely going to be delivered during the course of this week. Chief Justice, please allow me to disclose the fact that I erroneously omitted to mention the third reserved judgment, Waterford Estate versus Riverside, Body Corporate and others, 819/2024, square brackets 2026, ZASCA 3, delivered on 14 January 2026. Judgment in that matter was reserved on the 10th of November last year, 2025, and delivered on 14 January 2026. It is authored by myself and my brother, Justice Smith.
You co-authored it?
That is correct.
Okay, thank you. And the parted matters you mentioned in your questionnaire, what's their status?
As I'm going back to the division, I was phoned by my secretary this morning, and she told me that she had to ask another judge to roll the matters over until tomorrow because I'm going to have to deal with them when I go back to the division.
You have mentioned something that you're proud of, mentoring law students. At the request of the SACA IWJ, the Women Judges Association?
That is correct, Chief Justice.
Can you tell us a bit about that?
I take them under my wing. I take them to court with me. At some point, there was a group of students who came to court, and I took them to court with me, and I was doing motion court at the time. So I was with them in court. They were with me in court, and thereafter they all came to my chamber, and I took them through the applications, each application that I dealt with, and how they are supposed to attend to those applications. Okay. But in particular, there is a SMISO who is at the University of Zululand, who is right under my wing. So Now and then he gives me a call, I give him a call, and we meet perhaps when the schools are closed. He is right under my wing.
All right. Thank you, Judge Cele. I'll hand you over to President Mulemela to put questions to you, if she has any.
Thank you very much, Chief Justice. I'll start with a follow-up regarding the reserved judgments because it is of concern. I'm sure you've seen media reports. Concerns are raised about the delayed judgments in all the courts.
Yes.
I'm particularly concerned about the first judgment because it would seem that it's just a week shy of 8 months, which is quite unusual for the Supreme Court of Appeal, for a matter to have been reserved for this long. And the one in November has also passed the 3 months mark. Now, having acted at the SCA for 3 terms, you would know that sometimes the delay relates to a judgment that was circulated timeously, but is considered not to have been of a good standard by other panel members. So I just want to establish from you where contributions of substance done in relation to these two judgments. I'm just trying to establish where the hold-up is in relation to the handing down of the judgment. And I must also say, it is also quite unusual for judgment to go through their read-through conference and then thereafter get stuck. So if you could just assist me in relation to those two, just to give me your side of the story.
With regards to the first one, that is SA Board for Sheriffs. That judgment, as I indicated earlier on, in that judgment, the 3 judges, including the presider, concurred in my judgment. And they did not only concur, they made very positive remarks, which are very, very encouraging to me. As I already indicated earlier on, when it went back, when the judge who had indicated that she is going to dissent, circulated her judgment. That judgment went straight to the presider. Honestly, I don't know what the hold-up is, but the presider, as I've already indicated, I called the presider several times. I also sent some emails to her. That is the reason why I decided to call the deputy president, because I really was concerned about the delay. And I called the deputy president in February of this year. I am certain that the judges who concurred in my first draft are still in concurrence. I suppose that it's possible that the presider wants to perhaps write a concurring judgment, but I am not sure of that. It's possible, but it is completely out of my hands, and I am concerned about it. That's the reason why I phoned the deputy president. With regards to the second judgment, firstly, as I indicated earlier on, after the two judges had concurred in my judgment, there was a delay from the side of the other 2 judges. I phoned them to inquire as to what the cause of the delay was. they informed me that they've got other matters that they're working on. And I also expressed my concern to the presider. And the presider said that she's going to push and find out what the problem is. But eventually, they made their contributions. Now, let's come back to the issue of the matter going through a read-through conference and being deferred. The two justices who made contributions late, they are not in agreement on a certain point. So we agreed eventually that rather than having two judgments, let's reconvene, like I think we are going to reconvene either tomorrow or Wednesday. Let's reconvene and deal with those issues and see whether they are going to agree or not. But it is these two judges who made contributions late, who are not in agreement on a certain point. But my judgment still stands because it is my judgment in respect of which contributions are being made.
All right, thank you. Thank you very much. Judge Clearly,
Yes.
what would you say, and I think this is a question that has been consistently posed even in the past interviews, the preamble being that the SCA is the second highest court of appeal of general jurisdiction. And the question is, what would you bring to the table at the SCA as a special attribute from yourself?
I'm not suggesting at all that I'm an expert in criminal law, but I have been working with criminal cases for quite a long time. When I wrote my first two judgments, I was lucky to have on my panel people who have confidence in me. My first judgment that I refer to is the judgment of Ngobo versus the state. In Ngobo versus the state, the members of the panel in that judgment expressed so much confidence in me. When we were in court, during the course of the appeal, when we were asking questions in court, they expressed so much confidence in me. When we were at the post-hearing conference, they also expressed so much confidence in me. I wrote that judgment all by myself, and all the members of the panel, after I had written the judgment, commended me for the manner in which I wrote that judgment. At some point, there is a criminal matter, which was scribed by another judge. The most senior judge approached me, and he said, well, I almost said nothing. And he said, Judge Clearly, I know that you've been doing criminal work for quite some time. Will you be able to assist? I want to write a dissenting judgment in this matter. Will you be able to assist me? Am I right or am I wrong? And he said, I say this to you because I know that you are well experienced in criminal matters. I believe that when it comes to criminal matters, I will be able to enhance the bench of the SCA. I've also made a mention of of my exposure to shipping matters, I believe that I will be able also to contribute when it comes to shipping matters. I am no expert in shipping matters. I know there's my sister who is an expert in the shipping matters. I'm no expert. I'm not at all suggesting that I'm an expert, but I have had exposure and I will be able to assist. I will be able to enhance the SCA bench when it comes to shipping matters.
Thank you, Justice Chile. Thanks, CJ.
Sister who's an expert in shipping law. Which sister is that? Who's that?
She will be interviewed directly after me.
Oh, all right. One of your co-applicants. JP Tlalezi?
Thank you and good afternoon,
Yes, Judge.
Judge Aubrey. The two judgments referred to at paragraph 16.5, which are still the subject of other colleagues signifying their assent to the judgments, do they raise important and complex issues of the law?
The first judgment is, it deals with the interpretation of a certain section, that is Sheriff versus Sibuga. It deals with the interpretation of a certain section in the Sheriff's Act. I have interpreted that section in the manner that I see fit. I suppose my sister, who is not in agreement with me, also holds the view that, you know, her interpretation is correct. But I am of the view that, but being a single-minded person that I am not going to change my mind, because as I has already indicated, there are other judges who are concurring in the judgment. But it is the interpretation of a certain section of the Sheriff's Act. The other judgment, it involves a claim by the mother of a child. It's a loss of support claim. It's not a complicated matter. To me...
I don't want you to give me the details. It might be an indication to which direction are you going before the judgment is out. I only wanted to establish whether they complex issues or just run-of-the-mill type of cases.
Well, the first one, I will say it's complex because it deals with the interpretation of a certain section of the Sheriff's Act. The second one, it really is not complicated, to be honest. It was just a delay on the part of my other brothers who, when they explained to me that they are swamped with other work, I would not have pushed it any further than that.
Would you say those two judgments, especially the first one, will assist this body in assessing your level of competency in serving in the appellate court?
Most definitely. Yes. The first one in particular.
That will assist us?
That will, yes.
And it's not your fault that it's not before us at this stage?
It's not my fault that it's not before.
Yes.
Yes.
And just on a comment you made by the DP, releasing a draft judgment is not sufficient. You must also look at the quality of the draft itself.
Yes.
Would you agree?
Yes, I do agree.
Yeah, I didn't want an impression be given that once you've thrown out your draft, then nothing that we can complain or we can assess you. No, thank you, Judge Chile. Thank you, CJ.
Thank you.
Minister.
Thank you very much, CJ. Good afternoon, Judge Chile.
Good afternoon, Minister.
I noticed in your questionnaire, you say you are the chairperson of Chile Tribal Authority.
That is correct.
Since 2000.
That is correct.
Just to understand, how do you see the interface between the judiciary and traditional courts and your understanding of our current regulations in terms of traditional courts?
Firstly, there is a provision in the Constitution, I think it's section 211 and section 212 of the Constitution, that establishes the tribal courts. The most important thing when it comes to the tribal courts is to ensure that whatever it is that they do in the tribal courts is in line with the Constitution. Because the Constitution is the supreme law of the country. My role, because I serve as an advisor, my role is to always keep them in check, to ensure that whatever it is that they do as the council, it is in line with the Constitution. There is a lot that the tribal courts do. They try cases, minor cases, and if those cases, if they are not checked, they might find themselves failing to interpret the Constitution.
Maybe just to follow up on that one, Judge Tilly. The issue of the historic nature of tribal courts, that's what I'm asking,
Yes.
the interface between the judiciary and the traditional courts. But secondly, in terms of your view of the current regulations and how we intend to work on that. This is in the context, for example, historically you'd have that the tribal courts are regarded as not friendly towards women.
Yes.
And almost sometimes regarded as more oppressive. And my question relates to, do you think that the current proposals will be able to address such? And that's why I particularly chose this, because it's very rare you find a person who has a link between the traditional courts and also within the judiciary. And that's what I wanted to understand from your understanding.
Most definitely, my view, Minister, is that most definitely it will be of assistance. If you're talking about the historical background, in the tribal courts, there are issues. I don't want to find myself encroaching in customs, in other customs that are being practiced now, but there are issues like Ugutwala. The Ugutwala custom, if you look at it, it is actually kidnapping. So if it is allowed to carry on, really, I mean, to me, it goes directly to the abuse of women. So, because if a person is twalad, I mean, they take them away, they whisk them away without permission. Our historical background is such that when we continue in the tribal courts, we must ensure that whatever it is that we do in the tribal courts is in accordance with the Constitution. There are laws of the country. There is a common law, then there is customary law. If you look at both these, the customary law and the one has got to draw a line between the two and avoid The long and short of it is well, my view is that whenever we interpret the law, we must ensure that it is in line with the Constitution. And we cannot allow the historical background to continue as it stands, because it is a gross violation of women's rights.
Let's start with Commissioner Mangena.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner Mangena.
Hey, I always struggle to pronounce your surname. Where I come from is Chidi. And,
Yeah, okay. No,
that's how
it's
say
Chili.
Yeah, really.
Yes.
I'm troubled by your experience in relation to these two judgments that you're talking about, which are outstanding.
Yeah.
Is there no timelines within which colleagues should revert to you on draft judgments?
There is. The President has set a timeline for reverting. She has stipulated that the other charges must revert within 7 days.
And that period has it lapsed? Because at some point I heard you say that you went to the Deputy President.
Yes.
And I would assume that you went to the Deputy President because you were not finding joy from them. Do you feel that you were being ignored, or there is just no collegiality that's coming from their end?
Well, there is collegiality. There is collegiality. The problem is not. Well, I can't blame the judge who is dissenting, because, as I already indicated, she has already written her dissenting judgment. I can't blame the other colleagues as well, because they already commented. The problem is I'm sorry to say this, but it is with the presider, because when I spoke to the presider, she indicated to me, firstly, that she's swamped with work. There are other judgments that she's working on. And then she will say, okay, tomorrow. I've got my cell phone. She will say tomorrow. And then eventually I decided to report the matter to the Deputy President, because I was concerned about the delay, because I knew that once a matter has been assigned to a particular scribe, it matters not actually that it is being delayed by someone else. The buck stops with the person who has been assigned to scribe the matter.
Thank you, CJ.
But as I said, it is completely out of my hands and there's nothing I can do about it.
Commissioner Procedural.
Thank you, Chair. Good afternoon, Judge.
Good afternoon.
Yes, are you confident that you are ready to join the SCA? How many terms have you served as an acting judge?
Of the
Yes.
Of the SCA.
That.
Sorry, 3 stints. Sorry, three terms.
3 terms.
That's correct.
Yes, and you're confident that you are ready, barring all these problems that you have had now with the drafting of the judgment.
Yes, I'm confident that I'm ready. I'm confident that I'm ready because, as I already indicated, it is no fault of mine. It's not my problem. I mean, if you say that if one has regard to the drafting of, I don't have a problem with the drafting of the judgment. I already indicated earlier on that I circulated the judgment and the other judges concurred in that judgment and made positive comments. Your congratulations, well done, etc., etc. Then it gets stuck with a particular judge. Perhaps if I may just say something about the reserved judgments. The bench, as you will know, is multifaceted. It comprises of diverse personalities. There are many factors that one should take into account when dealing with reserved judgments and the reasons why there are delays in the reserved judgments. Now, when you are a scribe, you are put in a position where you have to find your way around these diverse personalities, but find a way in such a way that you don't compromise your independent-mindedness. But as I say, the panel comprises of diverse personalities. Sometimes you are lucky, like in the first two judgments that I scribed, you are lucky to have people who have confidence in you, who are going to support you. I'm not saying that others are not going to support you, but you are lucky to have, sometimes you are lucky to have a bench comprising of people who are going to support you, who are going to ensure that the judgment goes out as quickly or as speedily as possible. It doesn't happen all the time. So I'm talking about personalities. Also, the other factor that one has to take into account is the complexity of the matter. That too does delay the delivery of the judgment. The third point, is I will say it's the presider. Because depending on how the presider views things, another presider, you see, the matter that I spoke with earlier, Waterford, that judgment, as I indicated, it was reserved in November, but it was handed down in January. It was a complex matter. It is reportable. It is a complex matter. It is voluminous. It runs to thousands of pages, but because the presider wanted to ensure that that judgment goes out as speedily as possible, we managed to get it out within 2 months. So it also depends on the presider. There are many, many factors that one will have to take into account when deciding on the speed at which the judgments are supposed to be delivered.
Okay. Just now to ask the questions that we'll ask the rest of the candidates. Are you aware that there is an anti-sexual harassment policy for the judiciary? Sorry, are you aware?
Sorry, am I aware of?
Of the anti-sexual harassment policy?
Yes, I am.
You are aware?
Yes.
Have you taken the time to acquaint yourself with it?
Yes, I have.
And are you happy with its implementation in its current form?
Sorry, can you repeat that?
Are you happy with its implementation in its current form?
Most definitely I am.
Thank you. Thank you, Chief Justice.
Commissioner Nkonyan.
Thank you, Chief Justice. Good afternoon, Judge Cile.
Good afternoon, Commissioner Nkonyan.
Thank you very much for your responses. Just arising from your answers from fellow commissioners, I take it you are one of the people who have practiced in traditional courts, and therefore one of the people that could contribute in the development of customary law in the country. But you were asked, what would you contribute to the jurisprudence if you are successful at this high level as CA? I take it you know that the judicial system pertaining to traditional courts is based mainly on reconciliation of parties. And there is also the system that we all are experts in, which is based on Roman Dutch legal system. You told us about your contribution to criminal. Yes, I've heard you in maritime law, but you said nothing about customary law. Can one read anything more from that? Or can you explain yourself? What contribution would you be able to make should you be successful? As regards this law, some of us feel it is suppressed in one way or the other. Thank you, CJ.
Thank you. I would be able to contribute towards the development of customary law. As I'm going back to my division, there is an appeal. I'm not going to go into details with it because we are still going to hear the appeal. But I'm sitting as a presider in that appeal. It involves conflict of laws. It involves the customary law practice. It involves the Roman Dutch law, as you already indicated. At issue is I'm not going to go into details, but I find it very interesting, and in my view, it seems to me that it will be reportable because I have to deal with the conflict of these laws. The customary law, the Roman Dutch law. I have to deal with the conflict of these laws and decide, based on the conflict, which one should prevail, because it stems from the action of a king vis-a-vis the action of Inkosi. Inkosi has got a right to distribute land. The Inkosi is the custodian of the land, but at the top there is also the king. At the top there is also the the king. So there is a dispute between them who are supposed to distribute the land. Now, as I say, I find this to be very interesting, and I see myself writing a reportable judgment on this aspect. There is also the Ingonyama Trust involved. There are laws governing the Ingonyama Trust. So there are a couple of laws that are in conflict that I have to deal with. But to answer your question, I will be able to contribute towards the development of customary law. I just await a case, with appropriate facts where I'll have the opportunity to write on.
Thank you, CJ. Thank you.
Any further questions for the candidate? Prof. Janimhango?
Thank you, CJ. Good afternoon, Judge Chili.
Good afternoon.
I just want to ask you a question that I've been grappling with. I'm an academic, so sometimes things just bother me.
Yes.
The Constitutional Court, in my vote, counts 2 case, made remarks in that judgment that did not determine the outcome of the case. But those remarks were solely relied upon by the applicants in a subsequent case called Nation Movement case, and they won. So my question to you is, do these remarks by the Apex Court, by Chief Justice Mogoeng at the time, serve a legitimate jurisprudential purpose? And should the practice of invoking such remarks in subsequent litigation be encouraged as part of the interpretive ecosystem?
Sorry. What remarks? What remarks? were
The
made?
remarks in this case, in my vote counts too, they really don't have to matter to you, but the remarks were that the individuals can be put in a ballot paper in terms of Section 18 of the Constitution, the political rights. So basically, we used to vote for political parties, but in the last election in 2024, we also had to vote for individuals. This was because Chief Justice Mogoeng at the time made those remarks that he doesn't see anything wrong for individuals being put in a ballot paper. I'm just putting it informally. But such remarks were then used in the subsequent case, the New Nation Movement case, where the Constitutional Court subsequently said that the individuals can also be put in a ballot paper. So my question is, do these remarks serve a legitimate jurisprudential purpose? Should they be encouraged? Should we use them as some form of interpretive ecosystem? Thank you.
But the position as things stand is that individuals' names are being put to the ballot paper. They vote, don't they? I suppose.
They can be voted
So
for.
they can be voted for, yes, yeah. Well, that's the position as things stand, and I don't think that is the position as things stand, and
May I clarify?
yes.
Yes, please, because I myself, well, the candidate has not complained, but I don't quite understand your question. What is it about these remarks? Were they made obiter? Were they form part of the ratio of the decision? What is the thrust of the question?
Yes. Thank you, Chief Justice, and thank you, Judge Clearly. The Constitutional Court actually, in the subsequent case, did not want to determine whether those were obiter or not, but they did not form part of the ratio in the earlier case. So what the Chief Justice Mogoeng said was that, well, in just comment, which did not form part of the outcome, said, well, he doesn't see anything wrong for individuals to be put in a ballot paper. So my question is, going forward, should we take those remarks to be some interpretive ecosystem?
Well, the remarks that are made obiter are not binding.
Well, I think they are obiter, but the Constitutional Court refused to make that determination.
Yes, but my point is the remarks that are made obiter are not binding.
But in the subsequent case, when the litigants use those remarks, then they won the case. So my question is, what status should we put those remarks? Should we encourage them?
Well, my answer is that the remarks are not binding. So if the remarks are not binding, well, the court is not obliged to follow the remarks because they are not binding. They are made obiter. A remark that is made obiter is not binding.
I'll leave it there.
Yeah.
And was it you, Commissioner Ledwaba?
Yes, Chief Justice, thank you. Judge, I asked this question to your colleague who was here before you. I want you to convince me that you're bringing something different to the SCA. And so far, I haven't had. I know that you spoke about criminal law, but the thing that I was expecting you to talk much about customary law, you haven't, and you couldn't respond to the minister's question. So please give me something to take home with into the deliberations.
As I was responding to Commissioner Nongonyane, sometimes you have to await the facts that fit in a particular case in order for you to be able to develop the law on that aspect. I do have a customary background, and I will be able to contribute. I understand your concern about the fact that I was unable to respond to the question that was posed by the minister. But I do have that background, which gives me an edge when I'm dealing with matters of customary nature. So I will be able to contribute towards the development of customary law. But as I said earlier on, sometimes you have to wait for the facts in order for you to be able to apply the law on those facts. For as long as there isn't any case that is coming along with fitting facts, then I won't be able to. But I will be able to contribute on customary law. I will be able to contribute on shipping. I will be able to contribute on criminal law.
Thank you, CJ.
Yes.
Commissioner Malema?
Thanks very much, CJ. Judge, really, that question is going to, the way you are answering it is going to be used against you in the deliberations, because the question is not, will you contribute in customary law? The question is, give us your understanding of the customary law broadly, without tying it to specific case or to specific facts. That's a general understanding of the customary law.
Customary law deals with custom. It deals with traditions. Customary law is applied by the tribal authorities. Customary law, there are a lot of things that one can say about customary law. It deals with customs, it deals with traditions, that is the basic overview of what customary law deals with. Now, there are tribal authorities that practice, there are tribal authorities that like the courts, like you'll have the courts that deal with all other matters. But when it comes to customary law, it is tribal authorities that deal with customary law. My understanding of the applicability of the customary law is there are cases that are being tried in tribal courts. Those are only minor cases. But if there are serious cases, then they have to be referred to the courts of the land. Thefts of goods, squabbles between members of the family, which can be resolved, by customary law. What the tribal courts aim to do is to cause the parties to reconcile without going to courts. But there have been instances where attempts have been made to try to make the parties to reconcile without going to court, in instances where matters are so serious that they should not be referred to, that they should not end in customary courts. So what I do is to advise the council that in everything that they do, they must ensure that it is in line with the Constitution. Because even customary law must be in line with the Constitution. If it is not in line with the Constitution, then that custom should not be practiced. Just recently, there has been a regulation that has been made that entitles the courts to be commissioners of oaths. I was in contact, over the weekend, I was in the country, and I explained to them what it means to be a commissioner of oath. I say this with my understanding of what happens when people commission documents. I just went there to give them advice that they must be careful when commissioning documents, because I say so, because I know that sometimes a person is going to give you a call, Commissioner Malema, and tell you that there's a statement that I want you to commission, and you just say, okay, fine, come and pick it up, or you just send it. You say it was commissioned, when in truth and in fact, the person who was supposed to sign the document was not even present. Those things happen. So I was just cautioning the ingosi of the area that you must be careful with that. If you commission, a person has to be present.
The chairperson's mic is always kept on. I don't know what's going on here, because I've said things that are not caught on record, and it's going to be a problem later. Any further questions, colleagues? No? All right. That brings us to the end of your interview, Judge Tilly. Thank you so much for taking the time to come here today and making yourself available for this position.
Thank you.
You're excused.
Thank you.
Commissioners, we still have 4 candidates to interview, and it's 2:15. I propose that we take a 30-minute lunch and rush back here at 2:45. Otherwise, we have a long evening ahead of us if we don't do that. Okay, we'll adjourn until 2:45.
Judge Norman, good afternoon, Chief Justice.
How are
and
you?
Commissioners. I'm very well, thank you. Chief Justice.
It's good to see you.
Thank you.
We interviewed you for a vacancy at the Supreme Court of Appeal not so long ago.
That is correct, Chief Justice.
We have your transcript in front of us.
Yes.
And the rest of your papers. So we know, we have a good sense of who you are.
Yes.
So I'm hoping that we won't keep you. I'm just going to ask you to tell us briefly,
yes,
in your own words, who you are, that is relevant to this position you seek,
yes,
your academic qualifications, and your work experience.
Yes.
Brief, but don't leave anything out because your questionnaire says nothing at all about your maritime law experience.
Yes.
All right.
Yes, thank you. Thank you, Chief Justice. Well, my name is Thandi Nomen. I was born in Tarkastad, a small town between Queenstown and Craddock. I studied at the University of Transkei, where I obtained B. Juris and LLB degrees. And I did pupillage in 1996 in Durban. And after that, after I qualified for pupillage, I went to the Eastern Cape and I practiced in Bisho for about 5 years. Then I went back to Durban, where I developed an interest in maritime law. And then I was fortunate that the Maritime Law Association selected me to go and do internship in New York, where I was trained by Holland and Knight, which is a firm that specializes in maritime law. So I had opportunity to go to court, prepare, pleadings, and be part of the depositions that took place there. And thereafter, I came back to practice again in Durban. And in 2011, I obtained silk status. And at that time, then I opened dual chambers in Johannesburg, and where I practiced first at Pitcher Chambers, and then I moved to Thulamela Chambers, where I practiced until I was appointed as a judge in January of 2022. Well, as senior counsel, my practice, there were certain companies like Fosco, which before they moved to Johannesburg, most of their maritime work would come our way. And the Port Authority or Ports Authority would seek opinions from time to time. And I had mentored juniors who, I think I even mentioned on the last occasion, all went to obtain master's degrees in maritime law. I had obtained a certificate in shipping from the shipbrokers in Durban. It's a year-long program. And I then I practiced, when I was an acting judge in Durban on several occasions, I would have maritime law matters. Then I would have to decide those matters, grant orders in them. It's something that I was still very passionate about. And of course, with time and as practice grows, certain other matters take over, but not that you relinquish those. I had occasion, my first, well, it's the only case that's there now. I had put it up amongst the cases that I put up. It's the Rafael on the Nieming's case, which is a maritime case I wrote for the full court in the Eastern Cape in that matter. Judge Leach, before he was elevated, when that matter came up as I was acting, he said, with your maritime expertise, it's a maritime matter, I want you to cut your teeth in this one. So I wrote that judgment and I put it up. I hope the commissioners have it. I also mentioned it in Annexure A of to my application. It's the first case that I deal with in that application. That was sometime in 2003. I had occasion to work with fundis in maritime law like Ms. Tato Tsautse, who is an attorney, and that's the person that really maintained my maritime practice a lot. And I remember, I think I did work once with Mr. Mkunu, Titus Mkunu, also, who was also specializing in maritime law. And I was led once by now retired Justice Wallis, drafting pleadings for him in a maritime matter that I did with him. And I got most of the support from the firms that were doing maritime law. And I think at some point, I remember I had a brief also from Ms. Tina Siwendu before she became a judge, when she was still practicing in KZN at the time. Then my practice grew, and I ventured, I did a lot of work as well in land claims matters, because that, after the applications opened up, it became a big issue, and they needed, as we all know, they were paying far less fees than what they were paying in other industries. I think now the legal aid has taken over, and I did a lot of land claims matters, commercial work, energy law matters, administrative law matters. So my practice broadened in that sense. And I had way back, I think must have been around 1995, when I first worked, appointed by the Goldstone Commission to investigate taxi violence in the Eastern Cape. I was the evidence leader there. From then, I was also appointed as an evidence leader in the Pillay Commission, which was investigating some corruption in certain contracts involving the Eastern Cape government. Thereafter, I got appointed around 2013 by the Premier of KwaZulu-Natal, appointed to chair a commission of inquiry, which I sat with Reverend Ruben Phillips, together with Advocate Tandanani Mtembu, and I was chairing that commission. It was investigating an incident where the Department of Transport had advertised positions and people applied. And then what they did, instead of, in their shortlisting, they decided that these people were to engage in physical exercises, which they did. Unfortunately, 9 of them succumbed to the heat, because this was done in December, in the middle of summer. So then they met their demise whilst exercising. So that was the investigation I had to do. And I think when Premier Mkhize left, then I was appointed by Premier, the extension was granted by Premier Mkunu, who took over from him. And I think we finished it around June of 2015. And I have served as an arbitrator in one matter. And I have appeared in the Equality Court. I have appeared in the Supreme Court of Appeal many times, appeared in the Constitutional Court several times, appeared in the Competition Commission Tribunal, no, I beg your pardon, the complaints, what is it called? The one that deals with the complaints around television. I think it's the Complaints Broadcasting or Broadcasting Complaints Commission. I beg your pardon, that one. I've appeared there at the time when I was counsel. So I believe that, and I've had opportunity now to sit in one matter at the SCA, a maritime law matter. I believe that the scribe the scribe, who's also the presider, was very pleased with my contribution in that matter. I still get calls from pupils in Durban who wish to specialize in maritime. In fact, as early as about 2 months ago, one was discussing a topic that she wanted to advance in her master's program. So it's a field that I'm very au fait with, that I enjoy, and it's something that I believe I would contribute to the court in the event that I'm successful. Thank you.
Thank you, Judge Norman. You mentioned a judgment in the Supreme Court of Appeal. You've acted there.
At the Supreme Court of Appeal, I've acted, yes.
For how long?
For 4 terms, this is my 5th term.
You there now?
I am there now. My term will end at the end of May.
And you've had occasion to write judgments?
I have had, yes.
How many?
I've written, when I counted, I've written about 8 judgments so far. Yes.
All right.
Thank you.
All delivered? You've mentioned
all delivered except for one, which is what happened is already, for the last term, I was writing 2 judgments. The one was delivered before the term ended, and the one circulated before the term ended. But because of the Easter holidays, I got notifications from most of the members saying that because they were going away, and we all agreed that we shall await, because I also had to prepare for the interview, then I think they will only deal with the comments after the interview.
Right. Of the many things you've done, I didn't hear you mention your membership of this commission at some stage.
Oh, yes. Yes, in 2018, yes, I served as a member of the JSC. Thank you. Thank you, Jesus.
And you've been a member and held leadership positions in bodies such as the Black Lawyers Association, Advocates for Transformation, in which you were deputy chairperson.
Yes,
of your
that's
branch.
correct.
Saula, of which you were president. GCB, honorary secretary, LPC. What did you do in the LPC?
I beg your pardon?
What was your involvement in the LPC other than being a practitioner?
I was a practitioner. Are you reading from my...
I'm reading from your questionnaire.
Or from the questionnaire?
Did you have any special responsibility in the LPC, or you mentioned it?
No, I mentioned it, but I was involved in the drafting of the legislation. You recall the legislation for the LPC? Yes, for the LPC. Yes, I worked very closely with people like Mr. Mabunda, and them were because I was at the time, I think I was serving at the time on the GCP EXCO as a secretary of the GCP. So I was quite involved in the drafting of that legislation and the comments that the GCP and also unpacking the legislation as to how it was going to be implemented. Yes.
Mm-hmm. And upon your appointment as a judge, you promptly joined the South African chapter of the International Association of Civil Judges.
Yes, that's correct.
Okay. That's always a big plus. I'm very passionate about that body. It plays a very important role.
Yes.
All right. Thank you, Judge Norman. I'll leave things to President Mulemela.
Thank you very much. Thank you.
Good afternoon, Justice Norman.
Good afternoon, President.
Justice Norman, I won't be asking you many questions. You have been here before, and we have your transcript in front of us.
Yes.
And just as following up on the questions from the Chief Justice, I note that your very first acting stint as a judge was 24 years ago.
That is correct, yes. In 2003, I think, yes. Yeah. In the Eastern Cape, yes.
Yes. What took you so long to make yourself available for a permanent appointment?
Yes. The truth of the matter is that there were very few African females who were practicing as advocates. That is the starting point. So when I decided that I wanted to be an advocate, then I managed to attract a lot of work. From the time I was 5 years at the bar, I was already leading juniors. And that obligation which I had taken upon myself made it almost impossible for me to leave quickly. Not only that, I had ambition of taking silk, because in Durban, I became the first African senior counsel. It was an African female senior counsel. There was none when I joined that bar. So, coupled with the ambition of taking silk, the obligations of making sure that the junior bar does not suffer, especially Africans. You know, we all know how difficult it has been for African females in particular to actually make it within the profession. Even whether you're talking about attorneys or you're talking about paralegals and you're talking about advocates, it was very difficult. So when you are placed in a position where you're getting all the support that you need, then naturally you decide that I'm going to carry as many people as I can on my shoulders, make sure that people succeed in what they are doing. But also, the biggest challenge that we have coming from the small towns like Darkastad, those places, they need a lot of support. You will have, pupils that have passed matric that don't know where to go. And even if they know where to go, their parents don't have resources. So you carry on the burden of making sure that not only do you educate people in terms of the law, but also you actually make resources available for the upliftment of those communities. So it became, there were many calls made to me to make myself available. But I believe that the contribution that I've had at the bar, because by the time I left when I was appointed, there was now 2 other African females in KZN who were silks. So one would say, maybe you could have become a judge earlier and then you could have made a difference then, but I believe the difference that I made as well within the profession, being actively involved in making sure that the profession embraces the unique nature and the diversity that this country has, was not an easy task. So I did that with the cooperation of many of my colleagues at the bar, and we managed to do it, and we saved a lot of pupils from abandoning the professions. Some of them now, they are silks, and some of them are doing very well for themselves.
Yes, thank you. Just in passing, on the last occasion, you referred to a judgment that you co-wrote with Justice Skeppers, I think.
That's correct, yes.
I don't know whether you are aware that that judgment has since been confirmed by the Constitutional Court.
I am, thank you, President, yes.
All right,
yes.
Thank you. So you have acted at the SCA for a year now, so you are very familiar with the workings of the court.
Yes.
And I think you'd be in a position to confirm that the issue of reserved judgments is a standing agenda item at our court. It's discussed at every judges meeting.
Yes.
And you will confirm also that the acting colleagues have been forewarned that they will be assessed on the turnaround time in terms of circulation of judgments.
That is correct, yes.
Yes. Now, what is your turnaround time? Have you ever circulated a judgment after 3 months, after a period of 3 months? Bearing in mind that at the SCA, we have always strived to circulate our judgments within the term. It's not always possible.
Yes.
But I just want to know about your own personal record. What is your turnaround time?
Thank you. My turnaround time is, within 2 weeks of the hearing, I usually have my very first draft, which when I started acting at the court, I would give it to the presider first, because it was my first time acting, and we wanted to make sure that the style and everything else is in accordance with the style guide of the court. At the longest, I think I took was about maybe it's that matter of M versus V, the one that involved a lot of Italian law and a lot of Swiss law. So, and the interpretation of those codes came in a bit late to us. So that one, I circulated it a bit late, but I haven't I've never been reminded, first of all, by a presider that he's waiting for my judgment. The one that I wrote now was circulated, I think it was reported within 6 or 7 weeks. It went out within that period, not even circulated, because I circulated it within 2 weeks, I think, of the hearing, and then it went out before the 7th week ended. But I haven't had, even at the High Court, because at the High Court, Judge President Benenge told us when we were first appointed that when you reserve judgment, you reserve it to a date. So I have not fallen foul of having breached any of the norms and standards or the code of conduct, because my judgments get delivered quite quickly. Yes.
Yes, thank you. Now, from your response to the Chief Justice, you mentioned, you alluded to your experience in shipping law, which
Yes.
I think it's unquestionably good experience in that field. But my question to you is, have you, other than relating to matters that have to do with shipping law, would you say that you have had exposure to all the areas of the law at the SCA level?
Yes, I have definitely at the SCA, because even my judgments at the SCA, I have got judgments on insolvency law, I've got judgments on family law that involved the Hague Conventions, which was quite an interesting matter, and I've had judgments on criminal law. I have had a judgment on procedural law matters, and the one that involved tax issues. So I've had a whole range of the aspects of the law, either through matters that I set on, or through petitions, because petitions can be quite involved, and you get about 3-4 volumes, and you find that it's a particular area of the law that you have to focus on. Yes.
Thank you, Justice Norman. Thank you, CJ.
Thank you.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Judge Norman.
Yes.
I was looking in Judge's Matter on your resume.
Yes.
And it lists 5 key judgments there. None of them were maritime related.
Yes.
Okay. And then I'd like to ask you 2 questions.
Yes.
You say that you led evidence in the Pillay Commission.
Yes.
What were the outcomes of that commission?
I did not.
So that's the first question. And then the second question is, what is your opinion about the exploitation of our marine resources by foreign fishing companies in our territorial waters and even in marine protected areas, seeing that we don't have the vessels or the capacity to patrol our coastline? Thank you.
Thank you. Insofar as the Pillay Commission is concerned, I led evidence there, but I did not stay until the end of the commission because I had some personal pressing matters. So then they had to appoint another commissioner in my stead. I know that the matter ended up, Justice Ronnie Pillay was the chairperson of that commission. And I know that I think there were some challenges to some of the findings because it concerned a few contracts that related to the state. So that's my answer to the first question. About the exploitation of our marine resources, unfortunately, government just has to capacitate the enforcement law agencies that operate within that industry. It is the only way, because you've got to have small boats of enforcing agencies that are going to be arresting those vessels, or whether they are foreign vessels that are actually trespassing in a sense. Because we all know that, and I think I did, when you asked me the question last time, as to, we know the jurisdictions that are within. There's various zones, there's various passages within the territorial waters within which certain foreign vessels can operate. So once they transgress that, the only way is to enforce law, arrest them. That's the only way that you do it. So what it means is that government then must increase capacity in terms of the oversight and the enforcement of making sure that the laws of the sea are complied with and people respect our seas as South Africans. So if you do not have that, then the exploitation is going to continue, and the transgressions will continue, and people will think that it is appropriate to do that. Yes. Thank you.
Good afternoon, Judge Norman.
Good afternoon, Commissioner Postal Rotary.
Yes, I just needed to ask if you're aware of the anti-sexual harassment policy?
The anti?
Sexual harassment policy.
Oh, yes, I am. Thank you. Yes, I am. Thank you. Yes.
Are you happy with it? It's in its current form? Have you acquainted yourself with the policy?
I did, and I think I made some comments when we were invited to comment on the policy. I did make a few comments on it. But just like any policy, it's only when it's actually applied that it gets beefed up, because then that's when you actually see whether there are certain lacunas or certain areas that need beefing up. But in its current form, I'm happy with it because I had made some contribution to it, and I think it serves the purpose.
Who did you make the submissions to?
We made submissions through the acting judge president of the division.
Okay, thank you.
Thank you.
Justice.
Any more questions, Commissioner Malim?
We're together before you became a judge.
Yes, correct. Thank you, Commissioner.
Is that a question, Commissioner? Well, it would appear that there are no more questions for you, Judge Norman.
Thank you.
I just want to thank you for your patience with us, for coming back.
Thank you.
For the second time. I wish you all the best.
Thank you very much, Chief Justice, and thank you to all the commissioners.
Good afternoon, Judge Stein.
Good afternoon, CJ.
How are you?
As best as one can be under the circumstances to be here in front of all of you.
Yeah. You have nothing to worry about. You're in good hands.
Thank you.
Just remind me, you were last interviewed by this body in 2022.
That's correct.
But not for a vacancy at the SCA.
No, never.
It was the leadership, it was for the leadership position, the top position in your division.
That's correct, CJ.
Right.
Yeah.
Okay. Well, we do have your illustrious resume and your transcript, which is not particularly old before us. So even though you have not interviewed for the SCA, I think I can promise you that we won't ask you as many questions as we would ordinarily do.
Thank you.
But I speak only for myself. I don't know about my colleagues.
Thank you, CJ.
Can you just tell us briefly, in your own words, where you come from and what you've achieved, your academic qualifications, your work experience, and your extrajudicial work? You've done many things outside the judicial scope.
I will try and be as short as possible. I particularly come from a background where my parents couldn't afford to send me to varsity. So I obtained a scholarship from the Department of Justice. I worked and at the same time studied and managed to get my BUris in the same time that people do that full-time at varsity. Thereafter, I went to the University of the Western Cape, and it was very interesting that after a few years they had a conference showing who are all their students that became judges, and I quite like the picture where they say from bush to bench. But yeah, at UWC was for me, I was already a mother with a 2-year-old child studying part-time in the evenings after work. And thereafter, when I was at the Weinberg Magistrates Court, I was approached by UCT, headhunted to come and teach criminal procedure, law of evidence, and specific offences. And I then changed direction, and I've never regretted being spent 12 years at UCT as an academic. But in that time, I've been privileged enough that they granted and seconded me to the Jolly Commission to be a commissioner. And in the 3.5 years on the Jolly Commission, I most certainly have learned more than what I ever learned at the time when I've been a magistrate. So thereafter, the rest is, I acted since 2008. Yesterday, I've been 18 years on the bench. So that, in short, CJ, is my. I'm a mother. I am also a grandmother, and that's my personal detail that I can share.
Right. So, in these 18 years, well, that's just on the bench, you've written a huge number of judgments.
Yeah.
You had a big collection when you were here in 2022. So I imagine that between then and now, you would have accumulated,
yes,
and you have added to that list.
Yes, I did. My secretary and I've looked at the records, because I don't have the same secretary in 18 years. They've chopped and changed, retired. But it was all there in documents safe. I've delivered 500 written judgments. 32 of the judgments have been reported in the SACR and South African Law Report, and the rest have been on SAFLI and JDR and JOL, which we didn't add to the reported judgments. So more or less, CJ, that is what one has done in this time. But you don't keep score of everything, the extempores and everything else that you do. Yeah.
Indeed. And in addition to that impressive list, you wrote, published peer-reviewed articles as an academic.
Yes.
All right. How many?
I would say, if I have to count, and that includes some of the papers that were then later published as chapters in books. I would say about 10 or 12, but that excludes, of course, the Jolly Commission report, which was a report of 1,800, where one was a co-author together with Judge Jolly and together with Judge Sishi, who at that time served on the commission. If I can perhaps just share on that, I have 2 chapters on prison rights and prison systems I've done whilst I was already a judge in KwaZulu-Natal. Every 5 years, the publication came out and it has to be updated and one has to write. And after the second chapter update, I just didn't have enough time to keep all the balls in the air.
All right. You have acted in a leadership position in your division.
Yes.
As a deputy judge president?
Yes, I've acted twice as deputy judge president, and they've all been during the course of last year, CJ. Yeah.
All right. And it would be safe to assume that in a period of 18 years, in a big division, a big coastal division, you would have sat in the whole scope of legal issues, including legal issues that do not usually appear in other divisions, such as maritime law matters.
Yes.
Not so.
Yes.
All right.
But I've also served since 2024 in the electoral court, so there's also judgments delivered in the electoral court, which covers a wide variety of constitutional issues, etc.
I'm sorry, I almost forgot about that. But you have not sat in the competition appeal court?
No, I
How
have.
did you escape that?
I have not. By the time I've been asked by the president of the SCA, so I didn't opt for going to the competition appeals court. Yeah.
All right. Their loss. How long did you spend at the SCA?
I have already spent 3 terms, which 2 of them have been long terms, and I'm now busy in the 4th term at the SCA acting.
Oh, you're still there?
Yeah.
Your questionnaire says you don't have any reserved judgments.
I need to update that, CJ, because of the term that is just finished. I have 2 judgments. The one has been circulated and sent to the researchers in the SCA. That was not even 4 weeks ago that it was heard. The other one was heard on the 30th of March, and the president was the presider. It was an intellectual property matter, so that one is 70% written, but it is not finalized. So that's the update of my reserve judgment list.
But both fall well within the 3-month period.
Yes, definitely.
Envy you, that luxury.
Yeah.
All right. Just one more issue. Generally, almost all the professional bodies recommend, they endorse your candidature for this position, except for advocates for transformation, who also acknowledge your accomplishments. But they say, they make the point that the SCA currently comprises 72% Black and 48% female judges, and that your appointment, I'm not sure about the accuracy of these statistics, so luckily President Mulemela is here, she'll correct it if it's incorrect. And they say your appointment would have a negative impact on racial representativity. but in the same breath say your appointment would raise female representation to 50%. So there's an upside to this.
Yeah.
But then that's not all they say. Let me just find this page. They raise a concern that you do not, despite the many other things you've done, you do not report membership of any legal professional organization or transformation-oriented body, such as AFT, BLA, NADEL, and so on. Would you like to comment on these two remarks?
Yes, I can comment on that. Well, I just want to say that AFT KZN supported my.
It's national,
but not
comments.
national.
Yeah.
That they haven't come to that conclusion. But I come from as judges who are appointed, and in terms of the Constitution, either from the sidebar or the bar. I came from the academia. So as an academic, I did not join any of these professional bodies. And for that reason, I think that is absent from yours. But that does not mean that I have not put in a lot of work in the transformation of UCT. Since the time that I've started there, in 1996, I most certainly took it very serious that law students should indeed fulfill community service. And it took me a long time to ultimately succeed in presenting that to the board, and it became then part of their studies where they need to do mandatory community service. So in transformation aspect, because it was nothing giving you more joy than taking students who come from a privileged background to areas where they can go and teach maths and can assist people who has never heard about their rights, never heard about wills. And the legal aid office then also assisted in that. But yeah, Chief Justice, that is indeed something that when I was appointed in 2008, it was the same issue. Yeah.
Thank you, Judge Steyn.
Thank
President
you.
Muleme.
Good afternoon, Justice Steyn.
Good afternoon, President.
Yes, you indicated to the Chief Justice that you have acted at the SCA for 3 terms now, so I take it you are now familiar with all the goings on at the Supreme Court of Appeal, the environment, and are you of the view that you have all that it takes to be a judge of the SCA?
President, I think it's all thanks to you and also the DP, where one received the induction, first the notes and everything. So if you've never been familiar with the SCA, you very quickly learn how to become familiar with that. But you need to be practically there. And that most certainly, you now know how to handle your petitions. Tuesdays belong to petition day. You now know how to handle also your judgments. It is not something new to me to write for a panel of 5 because of the experience at the Electoral Court, and many times we sit as 5 members. But it was definitely eye-opening because conferences are different at the SCA in the sense of we do it in the Electoral Court mostly virtually. But when you have to defend your views in a matter, then most certainly you experience all of that. So I can only say that the first stint at the SCA merely exposes you to the new things that you need to learn. But after that, you become accustomed to what is expected of you, the hard work. It's no secret. Saturdays and Sundays belong to you preparing and being at court most of the times. And I can also say the environment at the SCA is an environment conducive of people assisting you and helping you. So at the time, in working in that kind of environment, you don't mind putting the extra hours and doing the extra research and coming home late at night. I have a very understanding husband when it comes to that.
Yes, thank you. You would know that, having spent 3 terms at the SCA, you know that delayed judgments is an issue that concerns all of us, and it's a standing agenda item. Now, I want you to tell us about your turnaround time. It's no secret that at the SCA, we strive to have our judgments delivered within the same term, which is not always achievable. So the 3 months mark is actually supposed to be the max. And I'd like to find out from you, what is your turnaround time, given the fact that all acting justices have been forewarned that your turnaround time in terms of circulating your judgments is something that you will be assessed on.
Yeah. Thank you for that question, President. I try and this is a discipline that how I also survived in my division by not being someone on the reserve judgment list, that I try and deal with the matters while still fresh in my mind. Some matters are more complex than others, and you need more time to reflect and think about it. But my turnaround time is usually 4 weeks. And hence, I try and deal with that. My method of preparing also for the ACA have changed from my very first term that I've acted there. I've in the High Court, when you deal with, and usually after being so long in the High Court, I'm always the senior. You have a different approach to dealing with the appeals. You discuss them beforehand and you discuss them afterwards. In the ACA, you don't discuss these matters beforehand, you discuss them afterwards. So you need to be very well prepared. I've learned now to make summaries far more comprehensive for my own work, so that I can, if anything goes in a different direction than what is anticipated, that one would be ready to then dissent in that regard. So my turnaround time, sorry, it took a bit long to say. I work on 4 weeks, and one can barely sleep, because if this is hanging over your head, then you know that the next term you will be on the back foot. So it's best to finish it as soon as possible.
It's sounding strange that I have to pose this question to you as somebody who has been in the legal profession. I mean, your legal career spans well over 40 years, but I'll ask the question anyway. Would you say that with your 3 acting stints at the SCA have exposed you to a broad range of, a broad spectrum of areas of the law?
President, most certainly. What we deal with in the division, and in a busy division like KwaZulu-Natal, where you deal from procedural law, law of evidence, you deal with regulatory law, maritime law, and contract law, delict, etc. At the SCA, the range is far broader than that. You would immediately have to get accustomed. Those of us who've done tax in the High Court knows how it operates, but there are many tax matters there. There are also many commercial matters there. So you need indeed to be prepared and deal with this all at once. And at times, and I think this counts for all of us, you may find that in your own division, you've dealt with the National Credit Act and the Consumer Protection Act, and all of a sudden at the ACA, there's a far more, the complexity is different. And the commitment from judges henceforth needs to be also different at the ACA.
Thank you, Justice Steyn. Thank you, CJ.
Thank you, President.
Thank you very much, CJ. Good afternoon, Judge Steyn.
Good afternoon, Minister.
I don't think I have a question much, but maybe you can comment. In 2012, you made I'll call it a transformational judgment of the summons being served in Facebook.
Yes.
I say this because we currently, I push for it to be used quite effectively in protection orders, in maintenance matters where we're battling as the department, where you find that the investigating officers and the magistrates they can't find the people who are supposed to comply with this. Are you able to make a comment about how this has really changed in terms of women empowerment, but also if you've been able to reflect in how this judgment has been transformative and how it has impacted on the life of ordinary women, especially as I reflect on this?
Sorry, Minister, if I could just get clarity. You're referring to the matter of CMC, I think, woodworking regarding the service in terms of Rule 4.
Yes, I think, yes.
Yeah.
You might not at that time having been dealt with it. So I'm just making a reference that that judgment, for example, has allowed us to be able to serve in relation to matters that on maintenance, where we can't find the addresses. For example, even on court orders, protection orders, in gender-based violence cases, that this precedent that in the judgment that we've been able to make has been able to help in that regard.
Thank you, Minister. I just also have to say that I think one of the professional bodies might have been corruption, what it says they couldn't find anything on social media of me. One of the reasons is because I don't do social media myself. And the strangest part was that one of the oldest advocates, Silks at the Durban Bar, Advocate High Court, SC, wrote this application just shortly after the rule. Literally, the rule changed on the Friday, and the Monday there was this application, and I think they were waiting for this. And the two of us are the most unlikely people to deal with that matter. And I see criticism if one reads broadly about it. I've been criticized that, I should have focused more on the right to privacy. But anyone that read that judgment would know it was heard on a Monday, and I delivered the judgment on the Friday because it was an urgent matter, and I've tried to, at best, deal with the aspects. And my knowledge of Facebook and how it could be used was merely by the affidavits that were filed. So my colleagues know well I'm not a social media person, but I'm hoping that if we are more innovative, but adhering to constitutional prescripts, that we would be able to assist particularly those that apply for maintenance. I started off in the Department of Justice, working behind the counter, paying out maintenance money. I was 18 years old. I just left school. And the plight of those people who need money for children is something that remains with you throughout your life.
Thank you, CJ.
Thank you and good afternoon, Judge Steyn. Here am I.
Sorry, JP, I didn't see.
Just to mention that the highlight of your judicial career started in Kimberley, the place with small beginnings but big endings in 2008, and then you exported to KZN, and the rest is history. But the question is really, when you were at the SCA, have you had an occasion where your drafts were not attended to by the presiders in particular, which somehow may suggest that your drafts required some high maintenance?
JP Lalisi, I have not had that experience, but I had a baptism of fire with my very first draft. Not from the presider, and I didn't deviate from what we decided we will do in the matter, but after it was circulated and there was a final product, one of the panel says, well, he would like to write he would like to write a concurring in the order, but dissenting on some of the discussions. And then that was done. So there was then a sort of a separate concurring judgment. But in that separate concurring judgment, the Supreme Court of Appeal's decision in Metayido was criticized as being wrong. And I had serious problems with that, so I then had to rewrite my part to deal with those aspects as to why I defend Metayido, and it was during our discussion, the emails that going forward, and because once you want to overrule a decision of the SCA, you're definitely interfering with the comity of the jurisprudence there, and you also need to make sure that the previous decision was wrong. Otherwise, we're sending out the wrong message. So after I've done that, and so this is now the second time the judgment has been circulated, I then get ready. So I asked the presider, can we now finally read through and it can be then delivered? Then that particular separate concurring was withdrew. So I had to rewrite my judgment. That was the third time. And you can't just go back to your very first one, because now there are other cases that you refer to and that you've dealt with. That I've experienced, but never from a presider at the SCA that did not immediately react or immediately dealt with it. And yeah.
Yes. Now, seeing that you'll be sitting on panels, are you a judicial officer who is subject to persuasion, accommodative of other ideas, and not rigid and say you will stay with what you have decided before?
JP, I think that when you write for a panel of 5, you need to have intellectual discipline. It's not about your view, it's about the view of the 5 of you. So unless there is something where you disagree fundamentally on the law, because in your view, let's say the interpretation rendered by one of the panel members and which they wanted to add to the judgment is not correct. So I don't believe in sticking to your guns, as we would call it all the time. That is not the test. The test is this a judgment that is good enough to go out of this panel? So you're not writing for yourself. You're writing for all your colleagues, and you need to accommodate this, and you need to be open to persuasion. I can't see that anyone who's not open to persuasion can survive in the Supreme Court of Appeal, where we work in large numbers in appeals.
Thank you, Justin.
Thank you, JP.
Thank you, JP. Commissioner Matolo Dlebo.
Thank you, Chief Justice. Good afternoon, Justine.
Good afternoon.
You know, I looked through the comments of the law bodies. Everybody recommends you.
Thank you.
And I just wanted, we are spoiled for choice, I must say, this time. But all the applicants have got good qualities. I just want you to convince me, give me something that will put you ahead of others.
Sorry, Commissioner, I didn't hear the last part. You want me to convince you about?
Is there anything that will put you ahead of others, you know, that you think you can bring to the SCA? Thanks.
I can start off by saying that I bring 18 years of experience where I not only dealt with one area of the law, didn't only specialize, for example, in criminal law or criminal procedure or the law of evidence, but that I had to straddle various areas. If one considers my judgments of the Naidu matter, of my electoral court judgments, then you will see that I have to engage many times with the constitutional aspects raised in these matters, and I've done so convincingly. But so my background is not only a background in one field of the law. Maybe when I left UCT, I was predominantly in the public law and criminal justice. But when I acted in 2008, JP Schlope threw me in at the deep end. He never gave me crime to do. He just said, you will do civil. And I never regretted that because, you have to familiarize yourself with everything, the rules, and most certainly all aspects of the law. But no one always knows the law all the time. One thing that the ACA has taught me is to be humble, because you learn and you remain a scholar for the rest of your life. And that's also what makes the work at the ACA so exciting, that you can deliver scholarly work. Yeah.
Thank you, CJ.
Thank you, Commissioner Madolo. Commissioner Gauteng.
Thank you, Chief Justice, and good afternoon, Judge Steyn.
Good afternoon, Commissioner.
My question also relates to the reports from the law bodies, but it carries on from the answer you gave to the Chief Justice. The BLA supports your appointment, and they say that it enhances gender representativity and diversifies the SCA's professional background. And they do so without discussing your commitment to transformation within the legal profession. And given your answer in respect of the work you did at UCT, I wanted to know whether there was anything else that you wanted to bring to the attention of this body to explain your contribution to the transformation agenda.
I can indicate to you, Commissioner, that transformation has different dimensions to it. There is what we will consider the demographic transformation, and that is when we consider Section 174, Sub 2 of the Constitution. But there's also the substantive transformation, and that is how you judge me by my work. If you consider my engagement in pretrial rights, the rights of prisoners, and also accused persons, also what has happened in the Zuma matter, you would know that I most certainly consider the rights of the marginalized as important. My master's dissertation dealt with the plight of victims of crime. I most certainly focus on rape victims, and I focus also on child witnesses. The forgotten part is this group in particular. I have submitted to Parliament as a young academic already in 1996 memorandums about bail legislation, and indicating that the route we are taking is wrong. I have published on those aspects, but transformation is also how you assist your acting judges, how you assist in helping them to become fully fledged judges. There are now some of those that one has taken under your wing who have become judges, those that would ultimately excel and definitely get into the higher courts because they're bright, they're smart in their own right, but you could help them and show them the ropes at a younger time. I serve on the SAJE Council. There is, I don't know whether Commissioner Hassan is here, but yeah, we give our time, well, the CJ will know. This happens usually on a Friday afternoon between 5 and 7, and you do so because you want to uplift other people. I have assisted in lecturing aspirant women judges. I've assisted in lecturing newly appointed judges. So that is all your time that you give in assisting those people so that the bench can be transformed and reflect also who is really the community they serve.
Thank you, Judge. Thank you, CJ.
Thank you. Commissioner Moimang?
Thank you, Chief Justice. Good afternoon, Justice.
Good afternoon, Commissioner.
Just one question from myself. The question is as to whether have you dealt with the right to property in terms of Section 25(1) of the Constitution? This is important given the challenges around the security of tenure in the country generally, but also dualism in terms of the property regime in the country. But I would want you to confine your response to one of the judgments that we dealt with, the
Hasodi Carter matter. Yes. Thank you, Commissioner. Yeah. I haven't written and published and know as much as some of the commissioners around this table about the right to property, but I've tried to make a good study of it. And in the Hasodi Carter matter, it was particularly important to look at the tension that there is between the right to property, Mrs. Carter's right, who was by that stage deceased, and also the right of the possessor, which was her daughter-in-law who made a claim to this property. So one had to analyze the Section 25 and consider the applicability and whether one can consider the right of her two daughters as the executors of the estate to enforce her right to that property. So one deals with the right to property in many instances where you would deal with PI applications, where you would deal also recently with an ESTA application. And at times it is really hard to interpret and to look at all of it, because that is something that's very close to everyone's heart. In the Carter matter, I can tell you someone that I have great respect for, and I hope I can say it here in this public, is Justice Lodlo, who was a mentor to me when I was acting in the Cape, and then here I sitting with him in a matter this. We say, no, one must understand children's right to property, and he dealt with it, and he was tearful about it, and I could really feel that pain. It's almost taking away, as he stated it, a homestead of someone. This house belonged to the family, and now this daughter-in-law is trying to take it. So that wasn't the way that I went about in dealing with the matter, but I most certainly try to deal as sensitively as possible, because it's two competing rights, the possessor and the right of the two daughters that were trying to protect the asset of their mother.
Thank you, Justice. Thank you, Chief Justice.
Chairperson?
No, thank you very much, Chairperson. I truly wanted to make a follow-up on the previous question. Good afternoon, Judge Steyn.
Yes.
My question would then be, based on what we've heard earlier on from Chief Justice as well as Commissioner Gottsel, how would you then advance transformation and access to justice at the level of the Supreme Court of Appeal? And attached to that, from time to time, you will keep on referring to us to your tenure whilst you were still at the UCT. Have you made any efforts I'm sure they were very good students whom you have lectured. Have you ever made any effort to follow through those students just to ensure that they settle comfortably within the fraternity where they have challenges? You make an effort, extra effort to assist those students so that they succeed.
I can deal with this because if you had looked at the CV and also the rest, I most certainly have not only taught at UCT. I've indicated UCT was the one place where one has instituted and also made sure that there is a mandatory compulsory community service. And when they fulfilled those duties, I went with them to places like Kaelicha, where we looked and speak to these young students who are battling to understand and couldn't afford extra. And moreover, when I was at UWC and assisting in part-time, and I had to help out because Professor Lovell Fernandez fell ill, I had no problem in my students accommodating them in the afternoon because they come from a different class of people who could not afford to be in class from 3 o'clock until 5 o'clock. And once you engage with them and you ask them why, when they explain to you that they also have part-time jobs to get an income and pay for their studies, then you work around their time and you allocate another hour on another day of your time to go back. But I didn't only do that, Commissioner, during the time, my tenure at the universities. I've indicated that I've done so throughout in assisting my acting colleagues and assisting also students who come and job shadow. One of the people at the bar, at the Durban bar, Mr. Byron Houston, could not get pupillage. So he was trying to do extra thing. And I said to him, young man, if you're prepared, you can come and you can job shadow. And I was still at the National Council of Correctional Services, but I'm going to teach you what discipline is. You're going to start also reading, and we're going to take an oath of confidentiality, and we're going to discuss these matters that you've read. And in the end, he was allowed to become and do his pupillage, and today he is an advocate at the bar in Durban. So I'm very mindful, but transformation is more than just that. It's not only about people that you teach, it's also what you do to the rest of the staff and whether you treat them with that necessary dignity and make a change. I've indicated that also previously, that at my own division, I've assisted in helping someone to pay their studies. And all of those things can be followed up and names can be given. I've assisted people when they lost everything in a fire to give back and help them. So transformation is a true sense of having that humility and Ubuntu for the rest of your people. Not only those that can assist you in your career, it is those that can least do something back that you do this for.
Commissioner Poso, return.
Thank you, CJ. Judge Steyn.
Sorry.
I have a bone to pick with you.
Yes.
When you left the Jali Commission, I replaced you, and therefore I should also get a credit as one of the co-authors of the Jali Commission report, not so?
I have no problem in sharing that, but how come I don't remember that you were sitting night after night with us when it had to be completed, and not only the hearings. I'm very mindful of the time that you had to spend in Ngome, but what I'm not mindful of is someone helping us writing in the evenings when we had to sit in. And I think people don't understand. It was like a small office, both me, just Jali and Sishi, and you were definitely not with us. Maybe in spirit, but not physically.
But anyway,
Yes.
co-authoring means writing.
Yes.
I had also had my input. I don't think you can deny that.
No, I won't at all. No.
Okay. All right then. Are you aware that there is an anti-sexual harassment policy?
Yes.
Have you acquainted yourself with it?
Yes, I most certainly did. I can even tell you what is in Annex A of that. And when you look at the interview on humanity, I've discussed the privileges that people have today in having a sexual harassment policy vis-a-vis what I endured when I was in the Department of Justice before as a magistrate and had to fend for myself and not have the privilege that the CJ now had given people to deal with sexual harassment.
So, did you put in your input? Did you send in your input?
I have not had an opportunity. We have in our division, the letter gets circulated and the JP at one point will ask that a specific person deals with that. So I have not been asked for that input, but I most certainly are grateful for what we have today and the product that it is, yes. But I need to say, Sajay, one has a second bite at the cherry, because now the Sajay is launching training on sexual harassment and what it should entail. And being part of EXCO, that is the things that we need to consider and comment on and assist in that regard, yes.
Thank you, CJ.
Anyone else? Commissioner Jivan.
Thank you, Chief Justice. Judge Steen, there's the matter of recusal in one of the cases, which was dealt with at your previous interview.
Yes.
At that stage, you said you had granted leave to appeal.
Yes.
What was the outcome of the appeal?
I can tell you what the outcome is, Commissioner. My colleagues decided that the matter, to set it aside and set it, that it should go on. And this matter is the one matter that was scheduled to be heard in November, December. And I was asked by the Supreme Court of Appeal to act, and I've indicated to DP Zondi that I cannot come and act because I have a commitment to go back to my division for this matter. And lo and behold, everything that one predicted happened. The plaintiff wanted to call a new expert, but it was triggered by the defendant's conduct, who called a different expert. Had this matter gone forward in the way when one ruled on it, it would have been finalized by now. But unfortunately, it is still ongoing.
So you're saying the judgment of it did go on appeal, and the appeal was that the case be sent back to you for consideration?
Since they've sent, but this will have to be understood in the context now where you've questioned your own impartiality in this matter, and you acted in accordance with the code of conduct and also what substantively, irrespective of all the other aspects, it was felt that it was more convenient that this court would deal with it, and I can only respect that decision. I may differ from it, but respectfully, once a decision is made, you follow it. Yeah.
So is it possible then, would you do the same thing again, considering in hindsight? I say this because, I mean, being a litigant, being involved in litigation myself, you can imagine it from the perspective of the parties, our clients firstly, and secondly, look at it from the perspective of the
Absolutely.
The legal representatives, I mean, what it does to the parties, it sets them back 1 year, 2 years, if not more, of having to take the case on appeal.
The fact is, it was set down quite urgently in light of the circumstances. And I'm mindful, I think the one thing that will show, but one is placed in this position, and this is, I'm trying to tread as carefully because you who appear also in court will understand that whatever decision this court will take, one of the parties will feel that it would not have been a fair decision. One has indicated that when the plaintiff questioned your impartiality, that this triggered an recusal mero moto. But ultimately, Commissioner, if the plaintiff is not the winning party, then the plaintiff will feel upset and felt that, well, maybe the judge now penalizes me. We have to put ourselves in the place of the litigant party. And I have all my life ascribed to the fact that you deal with a matter, you start and you finish it. In my whole career as a magistrate and as a judge, I've recused myself once, and it was this matter.
Thank you, Chief Justice.
One last question from me. How long do you still have to serve before your retirement?
I can answer that, CJ. I will complete 20 years at the age of 65. And as you know...
And you will not ask to leave?
No, I will explain to you. Being a judge is a calling. I love what I do. I get energy from what I do. So I will, and the minister is right there next to you. You know, if you turn 65, you ask the minister. The minister will say, well, you've said this at the JC. I can retire at 70. If God bless you and give you that health and strength, then that is the age on which. So yes, I'm 63 now. I have 7 years left.
Yeah, that's a long time.
Yes.
Okay. Thank you very much, Judge Steyn. Thanks for a lovely interview.
Thank you. Thank you to the Commission, and thank you, CJ.
How are you? Right. You said, I think it was in this very hotel, in that very chair, not so long ago. Is it
Yes.
on? Okay.
Yes, I did. I think it was in the same hotel.
Yeah, it was here.
It was in this hotel, yes. Thank you.
Thank you. We remember the interview. We remember what you said. We have and we even have it in writing. Your transcript is right here.
Yes.
So the length of this interview will be determined by the length of your answers to the few questions.
I hope to keep them short. You know what we say in court? I've read your papers. Is there anything you have to
Same
say?
principle here. All right.
Thank you.
I'm going to do what I did with the other candidates who are in your position, who have been interviewed recently. Give you an opportunity to tell us in your own words what you want us to know about you. Just remind us, at least those of us who were here, what your achievements are relative to this job, of course, whilst giving enough information. But we do have one new commissioner who was not here in October. So she must still get enough sense of who Judge Valley is from that short synopsis you are going to give us.
It's much easier when you went through the CV, CJ. Look, I've given you my detailed CV, CJ. I hope people have read it. I trust they have. I have a lengthy history. I've been in the legal field now for over 30 years, but before that I have a long history as well. I started off being as a trade unionist. I was involved in the trade unions in the 80s. I was a founder member of COSATU. I was from the 70s onwards to the 80s, a bit of an activist. And then I moved on to become an academic. And then the interesting thing there is my academic background is in sociology. My actual undergraduate training is in commerce. I've got a BCom degree. And then I moved on to move into law. I do have 5 degrees.
What are they?
5 degrees.
Yeah, what are they?
I beg your pardon?
What are those degrees? In which fields?
It's a BCom. It's a BA honors.
An MA in sociology.
MA, LLB, LLM. Those are the 5 degrees.
And one you obtained from the University of the Witwatersrand and one from Warwick University in the UK.
Yes, that's correct.
Okay.
That's correct.
Carry on then.
Yes. When I was a trade unionist, we also were quite involved in reworking things about the labor relations because they weren't very good. Or the industrial court at the time was not regarded as very understanding of where trade unions and where workers' problems come from. So we then worked about setting up an independent institution that works towards mediations and arbitrations. I was involved in that. And then if you look at my long history, I was a mediator, arbitrator. I was a senior commissioner at CCMA. I also trained CCMA commissioners, or practicing advocate. I was an acting judge in 2010, a judge from 2012. I was an acting judge of the Competition Appeal Court in 2016, a judge of the Competition Appeal Court from 2018, an acting judge president of the Competition Appeal Court in 22, and part of 23, and then I was an acting judge of the Supreme Court of Appeal from 2023. I still sit in the Gauteng High Court, Johannesburg Division. I've written a number of judgments in
all kinds of areas. I've given you 10. I had some difficulty choosing which 10. Some were obvious choices, others were not. And that's about it. Getting on in life, if you want to call it that. I don't know if there's anything else. Maybe people can ask specific questions.
Yeah, we will. You have long experience in the Competition Appeal Court, which starts in 2016.
Yes, that's 2016.
And you've even acted as a judge president.
Judge president of that court, yes.
Right. And recently you acted at the Supreme Court of Appeal.
The Supreme Court, that is correct.
How long was your stint there?
I had 3 stints in the SCA.
All right. And did you get an opportunity to write judgments during that time?
I did.
How many?
I wrote 3, there's 4 written. 3 I've written, there are 2 of which are just published in the latest law reports. One of which will most certainly be published very soon because it was a dissent. And I've just written another one which I don't know if that will be published, but that was in criminal law. So I'm not so sure the criminal law ones get published or not and how often, but they certainly don't get published in the SE law reports. They seem to get more published in the South African criminal law.
A judgment of a senior court is always reportable.
Is it always? It probably will be. Yeah.
All right. I've gone through the commentary from the law bodies. As before, no one has anything to say against your candidature. If anything, I think I can say without fear of contradiction that your credentials are impeccable.
Thank you.
The one thing that could, and this is something I hate raising with candidates, especially because I know that the older the judge, more often than not, they will have had a longer term, on the bench and more experience. So an older judge is gold.
Thank you.
But that's not how it's saying. There are other considerations to be taken into account. The JSC does not want to interview someone today and in 18 months they're retiring. There are cost issues and so on. So I just wanted to find out, how long do you still have to serve before retirement?
I have.
Sorry?
3 years.
3 years.
3 years left. I will be 67 in May, and I've got 3 years.
And should that be held against you?
Should I?
Should that be held against you, that you have 3 years?
I hope not, because I do believe that I will bring substance to that court, that I will add value to that court, however little time there is. I wasn't lucky enough to get in earlier. That's just how it panned out. But I still got something to give. And I think I'll add significantly to the development of the jurisprudence in this country, but coming from that court. I've already demonstrated that I have, and I can contribute to the development of jurisprudence in this country. I've written some, I hate to say this, but yeah, some power-breaking judgments. There's no doubt about that. I've given you 10 as a sample of the quality of my work. The law bodies have commented on them, as you rightly say. So I got 3 years to give to that court, and I think that court will benefit from what I have to offer to them. I've met the colleagues there, I've spoken to them, I've worked with them. I understand that court a lot better now than I did before. And I think I'll get along very well with them, and I think together with them, I'll be able to develop not just myself, but the jurisprudence of this country.
Thank you, Judge Vadi. President Mulemela.
Thank you. Good afternoon, Justice Valley.
Good afternoon, President Mulemela.
I think I'll start where you left off, where you were talking about your interaction with colleagues. Would you agree that collegiality is integral to the success or successful running of the SCA?
Absolutely.
Why is that the case?
And I also would like to say this, collegiality, involved in my undertaking some very robust discussions and debates, but it didn't affect the respect we had for each other. It didn't affect the rapport we had with each other. And yes, I enjoyed it. I mean, I learned a lot from some of the people there. There are people who have a lot to offer. And I did pick up from them, and I hope to still pick up from them. I hope they learned from me too. I mean, I don't know, but we had some good discussions. But I accept you wholeheartedly the proposition that collegiality is essential. I think collegiality is essential not for the sake of getting along. I think collegiality involves listening. I think it makes you a better jurist. I think it's just more than just person skills. I think it involves understanding where they come from and why they think like they think. Because we really, at the end of the day, what we are there for is to issue a judgment that tells parties what we think the answer to their problem is. And we don't always see it the same way. But if we're not going to respect and we are collegial towards each other, you're not going to get towards an answer that is, I believe, just and fair.
Yes. And you'd agree that it's even more important in a court that sits only in panels. I mean, you are not going to decide any matter alone or by yourself. You'll always be with colleagues, so it's important for you to get along with
Absolutely.
colleagues.
The only person who sits alone is yourself, just in the 17.2Fs, but everybody else will never have that. I see you laughing, but that's true. That's what happens there. Yeah.
So, Judge Valley, you've never had any issues around collegiality being raised?
Not that I can think of, but I did say that we did have some discussions on issues that we disagreed, and I think that will constantly come up. It's still going on there.
Absolutely, yes. No issues have been brought to my attention as well. Your turnaround time in respect of handing down judgments, what is your personal turnaround time? You know that we aim to have our judgments delivered before the end of term. It's not always achievable, but then it's as soon as possible. So the 3 months deadline has never really been a benchmark at the SCA. We strive to hand down our judgment in a lesser period of time. But like I said, it's not always achievable. But it has been drawn to the attention of all acting colleagues that you will be assessed on your turnaround time in terms of circulating your judgments. Have you ever circulated any of your judgments late?
Never. I have issued my judgments within 2 weeks of the sitting, maybe 3 weeks of the sitting. I've never issued a judgment outside of term time. Sometimes it doesn't get out before term is over. There's a process that's involved there that's quite involving, that's quite cumbersome sometimes. You got to send it to the researchers. They then go through style guides, they go through a whole lot of things, all very necessary, very, very necessary. And once that is done, I mean, there's sometimes differences in style between what I experience at the SCA and what I see the CC writes. So those sorts of things, they must do, and they take their time, and they're very busy as well. And then you wait for it, and then there's a conference, and everyone comments on it, and then there's a further discussion, then there's a full conference. So it takes a bit of time from the moment it's written to the moment it actually goes out. But yeah, I think that process is very necessary. That's where collegiality is very important.
Yes, but
And so I give it to you within 2 weeks or 3 weeks of the sitting.
Yes, thank you. Quite apart from your own judgments where you are the scribe, you have never caused another colleague to be late by making your contributions?
Never. And I strive to do that even in the petitions. You are well aware of the petitions, President. I make sure they're out by the Wednesday or the Thursday, the very, very latest. I've never done that to any of the colleague. I'll always strive to do that because it doesn't help anybody to hold on to it. You just have to drop everything else, finish this, and come back to what you're doing.
Thank you very much, Justice Valley. Thank you, CJ.
Thank you, President. Deputy Lizzie.
Good afternoon, Judge Valley. Here am
I can see you, but I don't see you on screen though.
Oh, okay.
Thank you. Judge
That's
Kaletsi.
That's wonderful.
Judge President.
Yes.
How is
Yes. That's why I must say I'm humbled by your commitment to serve and to add value, especially at the Supreme Court of Appeal. Given that we've got 3 candidates for now for this round, vacancies and more than 3 candidates vying for the 3 positions, would it offend you if you were to be called from time to time at the SCA to serve as an acting judge and in line with your commitment to serve and add value for the sake of stability, given that you only have 3 years to go?
When a calling comes, one has to deal with the calling. Of course, it's not a calling one ignores lightly. So yeah, one should be able to serve when it happens. We'll have to look at the situation when it comes, depending if I have any other commitments. Sometimes one have outstanding judgments in other courts, etc. But I respect the calling.
Yes. And it can also be at the Constitutional Court during this period.
Yes. Look, those callings are very important and they must be respected. You should take into account the needs of the court as well as your own needs. You balance them, your own commitments, and to a large extent, they can be easily accommodated. I have one advantage, though. I try not to keep any outstanding judgments. So if you have outstanding judgments, it's become a problem when you're now being called to another court and then you start leaving this work. I try and make sure all my judgments are out as soon as possible, right or wrong, but they must be given to the parties as soon as is reasonably possible.
Yes. I like what you're saying because it's just to clear everyone's mind that it's not for retirement salary that you're actually going for. It's to serve.
It's to serve, yes. Thank you.
Thank you. Thank you, CJ.
Commissioner Poso?
Thank you, Chief Justice. Good afternoon, Judge
Good afternoon.
Judge Valley, some people would describe...
I'm having a slight difficulty with hearing. I would just say, I'm sorry about that.
Some people would describe you as a maverick. What do you say to that?
A maverick?
Yes.
That's a strange. That's the first time I've heard that I'm a maverick. I've heard that a few other things, but yeah, I don't think being a maverick. I think there's even a newspaper that calls itself a maverick. It says it's a daily one, though. So yeah, I don't think I wouldn't treat that as an insult, never. But I certainly am a thoughtful, independent thinker. I do think outside of the box. I do make an effort out. Remember this. This is very important for me to say. I don't come straight from BALLB, law, and know nothing. I come from commerce, I come from sociology, and I come from being a trade unionist and an activist before. So I have a certain ideology. I do have ideology. If there's anyone in this room who tells me they're not ideological, I'd like to have a further engagement with that person. So yes, I do, but I try and do justice to the cases justice to the parties when the cases are before me. I'd make that a special effort. Whether it's criminal law or whether it's civil law, even competition law. I mean, I was thrown deep in competition law. I've written, last time I was asked how many judgments, I thought I had 3. I looked again, I got 9. And I was the acting judge president. I make an effort to go beyond what it is. And I must say this now to all the lawyers here, I never confine myself to their heads of argument. I never, ever confine myself to what they say are just how a case should be. Never. I do my own research. So if that makes me a maverick, then I'm a maverick. Then I'm a maverick.
I mean, I must say there's certainly nothing wrong with that.
Thanks.
With thinking outside the box and with being independent. There's certainly nothing wrong with that. I just wanted your comment.
Thanks.
Yes.
Thank you so much for that. Thank you.
Now, you are aware that there is an anti-sexual harassment policy,
Yes.
and have you acquainted yourself with it?
Yes, I've nothing new in it for me because remember I come from sociology where we made a big deal about the patriarchal nature of our society and there were special courses teaching that. So I'm talking now in the 80s already. Yes, I've acquainted myself with the policy.
Have you made any input to that policy?
No, I haven't made any input to that.
Will you be able to perhaps have a look at it and make some input so that it is improved? My understanding is that it's a work in progress. Would you undertake with your sociological background to improve on it?
Well, maybe I could, maybe I wouldn't, but a lot of this is going to have to depend on how it plays out in practice. Much of what we've already experienced has already been captured in that policy. The policy itself is in my view, is comprehensive. For me, and I must say this, the issue is not writing policies. The issue is changing behaviors. For me, what's written down there should be internalized by every judge, should be internalized by every member of society. It should come as part of it should be your second nature. You should understand the limits, you should understand the roles, you know. So it's not the question of how great policies we write. We can write the best of policies. What's important is how much of the values underpinning that have been internalized by us. And that's what we need to do. We need to build on that. I mean, as a judge, I believe there are often situations where I'm no doubt having power over someone of another gender. There's no doubt about that. And one must be aware that it can easily be abused. And yeah, so for me, it's not a question of the policy in itself. Important as the policy is, we need the policy to give guidance to people, but we must work towards internalizing the values.
Thank you, Judge Valley. Indeed, the policy is not self-executing. It will require the buy-in of the judges.
Yes.
Thank you, Chief Justice.
Thank you, Commissioner. There are no more questions for you.
Sorry, Judge.
Thank you.
Sorry.
Suddenly there are two hands. Professor.
I didn't put myself on the register. Good afternoon, Judge.
Good afternoon. I can't see you, but...
I'm sorry, where's that voice coming from?
I'm here.
Oh, it's Commissioner.
Are you there? Commissioner, I don't know what your name is.
It's Jeevan.
Jeevan.
Umesh Jeevan. I'm reading from the report from the General Counsel of the Bar.
Yes.
And I think it follows up on the Maverick.
Commissioner Jeevan, if you just keep your hand away the words, thank you.
Okay.
I'll probably have it more.
It says the candidate's occasional disregard for binding precedent, especially when preferring his own earlier judgments, is concerning. Even if a candidate has a sound reason for disagreement with a higher court's order and articulates this in the judgment, precedent is binding. Failure to follow precedent may be interpreted by the public as a disregard for the rule of law. Now, would you like to comment on the first part? It says the candidate's occasional disregard for binding precedent, especially when preferring his own earlier judgments, is concerning.
Commissioner Jeevan, this question's come up a few times before. If you looked at the transcript, I've answered it before, but I'll answer it again. They're referring to one particular case in which it is involving contractual relationships. I take a particular view on contract. I've, before coming to this, reread something that Justice Froneman said, which was identical to what I've said. It goes even further. His came out after mine, And the judgment that they're referring to came out after mine. And it is a debate and a discussion that went on as to how this law is developing and where it should go. My judgment canvasses all the early cases, all. I was asked by some people not to have used all that it is an academic paper as opposed to putting it into a judgment. So no, I don't think that the criticism is fair. That they've seen necessary to repeat it all the time is unfortunate. They've heard the answers before, but they've just repeated it and regurgitated it. It's unfortunate, but there's not much substance to what they're saying. That they must follow precedent, I think that's absolutely essential. I said this before. It is an essential component of rule of law. It brings certainty to the law. We need it, but that doesn't mean there is no room for development. We do not refrigerate the law. You can't. Oops, sorry. Somebody wants your attention more than me. Commissioner. Are we okay? So, Commissioner, we can't. The law is a living thing, it has to be. It has to be. We're going to deal with all kinds of problems and all kinds of people and all kinds of issues. So no, it's not correct, but yes, I do believe precedent is urgent. It is crucial. And I will follow precedent where I cannot go, even when I disagree with it.
Thank you for the clarity.
Thank you.
Indeed, you have answered this question before more than once.
Thank you, Chief Justice.
Professor Janimhang.
Thank you, CJ. You haven't been asked this question. Good afternoon,
Good afternoon.
Judge Valley.
Good afternoon, Commissioner. Or should I say Professor? Commissioner?
Either is fine. Judge Valley, I want to ask you a question about your case, the celebrated case of Democratic Alliance versus Minister of International Relations. That it is in your papers.
Is it one of the...
Yes, it's one of the cases that you submitted.
Okay, that's the international law.
Yes.
International law.
Yes, about Mrs. Grace Mugabe's entitlement to customary international law immunity as a spouse of a head of state. So what I found interesting about that case is that the minister relied on the Diplomatic Immunities and Privileges Act of 2001.
Yes.
But your outcome relied on the Foreign States Immunities Act of 1981. You referred to a provision there, Section 6A, that states that it says, a foreign state shall not be immune from the jurisdiction of the courts of the Republic in proceedings relating to the death or injury of any person. But before then, you also made references to Section 2, subsection 1 of that act that says that a foreign state shall be immune from jurisdiction of the courts of the Republic except as provided for in this act. So there was an exception that you relied on, which is Section 6A, that says that I've just mentioned. But before Section 2, subsection 1, there is another subsection, there's Section 2, subsection 3, which provides that the provisions of this act shall not be construed as subjecting any foreign state to the criminal jurisdiction of the courts of the Republic. So in your outcome, you are implying that a head of state will be found, will be brought before our courts for criminal proceedings. It will not be immune from criminal jurisdiction, because that's what you said. You said even President Mugabe, in terms of Section 6A, will have to be brought before our courts. So I was just wondering, you don't mention Section 2, subsection 3, that says that nothing in this act shall be construed as subjecting any foreign state before our courts for criminal proceedings. I was just wondering, maybe you have forgotten, I was just wondering if you did think about Section 2(3), because you really are not talking about it in this, but it's very crucial, especially if you are saying even if it was a head of state, he would have been subjected before our courts for criminal proceedings.
Look, I don't know if I haven't looked at the section, and I'm thankful to you for bringing it up and for asking me to think about it. But this is what my proper answer would be. It's not a judicial answer. I'm not trying to be scuffing. I don't know if that by looking at that section, the outcome would have been different or addressing it. I can't remember when I wrote it. I think I wrote it quite a long time ago. It was 2018.
2018, yes.
2018 is a bit of a long time ago. It's 8 years ago. What I did do then is I did a comprehensive analysis of international law. What was I remember there was a usus or usus or whatever they call it, and there's something else. And I mean, look, if you speak to any lawyer, they don't really get international law cases on a daily basis. Neither do our courts, they don't get them on. So I did a thorough analysis. I made sure I understood and applied the law as it was, and I came to the conclusion that it didn't apply in that particular case. I'm not sure if they chose to appeal, because I don't recall having a leave to appeal in that one. And it would have been nice if they did. I issued that judgment also in 2 weeks of having written it. 2 weeks. Issued the judgment straight away. So most of my judgments go out as quickly as I can. But I can't say if that section had an impact. It sounds from what you're saying is that had I done so, it would have only enhanced my reasoning. But maybe not, I don't know. Maybe the opposite.
Yes.
The opposite.
It would have been the opposite.
Would have been the opposite. Then,
but then again, Judge Valley, it's really neither here nor there, because the immunity fell away when the president was ousted from office.
Oh.
So she will still be required to face our courts. But I just wanted to say that you really did a very good job in the analysis of customary international law. It's just that I was wondering why not use a new act and also not discussing that section.
I can't remember why, but thank you so much for the question and thank you for the comment.
Thank you.
Any more questions for this candidate, commissioners? No. Thank you, Justice Valley.
Thank you very much, and thank you all for your time, and I wish you well in your endeavors.
You too.
Thank you. Bye.
Good afternoon.
Are you well?
I'm well, thank you, and you?
I'm fine, thank you. Well, we've been running behind schedule since the first candidate. We do apologize for keeping you waiting.
No problem. Thank you, Chief Justice.
Hopefully we won't be too long with you, because you were here not so long ago. We have your transcript and we remember quite clearly who you are. But you
sounds
can
good.
remind us, especially the new commissioner who was not here in October. So I'm going to do what I did with the other candidates and give you a chance just to give us your resume briefly, your academic qualifications, and I know you have vast experience. Just try to give us the headlines.
I am 58 years old. I matriculated in 1985. I then obtained my BE Juris and then my LLB degree. I started working as a prosecutor after I was appointed in 1993 as a magistrate, where I served for 20 years. I then came to Johannesburg High Court, first as an acting judge in 2010, and then I was appointed permanently in 2013. I've now currently served almost 13 years as a judge and 36 years as a total experience.
You were a teacher at some stage, not so?
I was not a teacher, but I did do some teaching at the University of the Northwest.
I think I've asked you this question before.
Pardon?
I think I've asked you this very same question before and you gave the same answer. So what did you do there?
I taught at the Lead School. I did criminal and civil procedure. So I've done that for a couple of years. I also got involved with the delictual department where I assisted them. That was also on a part-time basis. Yes, I think that's
That
about
is teaching.
That's my
you were a
teaching,
teacher.
yes.
All right. How long did you act at the SA? Are you still there?
No, I'm not. The last time I acted was last year. I've done 4 terms now.
And as I recall, you had managed to produce a few judgments during your acting stint.
I did.
How
I
many?
finalized 8 judgments, of which 5 were reported.
Yeah, all right. Between October 2025 and mid-April 2026, anything happen, anything of note that you'd want to bring to our attention? Any skeleton come tumbling out of your cupboard or a new achievement?
Chief Justice, after October, I went back to the Johannesburg High Court. I had 2 very heavy terms. In the last term of 2025, I produced 27 written judgments. In this term already, I've produced 13 written judgments. There are still about 6 outstanding just from this term, so that would be a total of 20 judgments. You would know, as a senior of the Johannesburg High Court, I've also now presided in another 6 full court appeals. They have all been finalized. I'm also case managing 2 major big cases. The one involves another class action. And it's something that is quite taxing because those things are not rostered in your normal activities. So when you are case managing a matter, you have to do case management meetings and you have to deal with all the interlocutory applications in between. That means that you have to do it either from 8 o'clock to 10 o'clock in the morning or even after hours. So you also have to schedule in all of that. So basically the last 2 terms, roughly I produced about 44 judgments.
That is an extremely heavy workload and a very impressive output. And people just don't believe when we tell them how hard judges work for little pay. But that's another debate for another day.
Yes.
Very well done, Judge Windel.
Thank you, Chief Justice.
All right. I will hand over to President Mulemela. I don't know if she has any questions for you.
Good afternoon, Justice Windel.
Good afternoon, President.
How are you?
I'm very well, and you?
I'm well, thank you. I won't be asking you a lot of questions because, as the CJ pointed out, we have your transcript in front of us. Just maybe one question relating to collegiality at the Supreme Court of Appeal. I want you to link it with the delivery of judgments because, when we are talking about collegiality, we're not only talking about being friendly with each other, and we are not suggesting that judges should not, write dissenting judgments where they have a different view or separate concurrences. It's not about that. I just want you to very briefly tell us why there is a need to have collegiality at the Supreme Court of Appeal as an appellate court. Thank you.
Yes, I think it's very, very important because you work in panels, you work as a team. There are robust discussions, there are personalities that you have to work with. So it's very important to be collegial towards your colleagues, to respect their views, and also to try and produce one judgment in the end. Sometimes it takes a while. There's maybe minor issues that you differ upon, and it's very important then to work together as a team to produce one judgment. So I think it's, especially in an appellate court, it's a very, very important issue and something that you have to do. There must be collegiality between the judges.
And you'd agree that in terms of you'd agree that in terms of writing judgments, when you are the scribe, and circulating judgments and handing down judgments, not only is it of importance for you as the scribe to circulate your judgment timelessly, because that determines now the pace of everything else that will follow, but not only is that crucial, what is also crucial is your own contribution to the judgments of other colleagues as they circulate those judgments.
Yes, I agree with you. And especially it's when you go back to the High Court after you've done a stint in the Supreme Court of Appeal, you're now dealing with your normal workload and then a judgment would come in. You'll have to leave everything else because it's important for that scribe, for you to do your input. So sometimes you find that people take some time to get back to you with their comments. I try my utmost best to immediately look at that judgment and spend some time. Sometimes it takes 2 to 3 days to go through a colleague's judgment. But that is also so important because you also have to strengthen the scribe by your comments.
Yes, thank you very much. Last question. If you were to be asked, what special attribute will you be bringing to the SCA? What will your answer be?
President, as I've indicated, I've got vast experience. I've been a presider over court cases now for 33 years, first as a magistrate and now as a judge. I have been fortunate enough to deal with 2 class actions, and I'm currently case managing a 3rd. So I think I bring some expertise in that field, but not only that. I think my vast experience over the years in criminal matters in Johannesburg, I was also fortunate to sit in the tax court where I produced 7 judgments. So I've got that expertise. So I think I bring a wealth of knowledge to the Supreme Court of Appeal, and I truly believe in the about 12 years that I've got left to serve, that I will make a valuable contribution to the Supreme Court of Appeal.
Thank you, Justice Window. Thank you, CJ.
Thank you, Pres. Commissioner Gotsa.
Good afternoon, Judge.
Good afternoon.
Judge Windell, the law body reports.
Yes.
The AFT describes your transformation record from 1998 to present. The GCB says that you have a proven commitment to transformation within the legal profession, and they've said this on 2 occasions prior to this one. The BLA on 2 September at your second interview said that they support your appointment. However, amongst the documents that we received for this session, they now say that they do not recommend your appointment because although it would enhance gender representation and bring magistracy experience into the appellate judiciary, no information could be found on your support of the transformation initiatives. Now, I just want to ask, do you again confirm your commitment to transformation? And is there anything that you think happened in the past 6 months that would change the recommendation to this point?
I did notice that they are not supporting my candidacy, and I was surprised because on the last occasion they did support my candidacy. I could not find anything negative in their comments. All I can add is that since 1998, I've been involved with the Law, Race and Gender Research Unit in Cape Town. I've done many outreach programs, not only as a magistrate, but also as a judge. I am part of the South African chapter of the International Association of Women Judges, where I was a provincial coordinator for some time. And I've been involved with the Bridget Mabandla Aspirant Women Judges seminars, and I've taught again in January of this year, where I taught on Rule 41A and the eviction on eviction matters. I've taught on a variety of different topics. I've again mentored a student, and a final year LLB student that spent about 4 weeks with me in chambers in the last 6 months, where she went to court, we discussed, and that's how I can empower and contribute to transformation.
Thank you, Judge, and thank you, CJ.
Thank you, Commissioner. Commissioner Posa.
Thank you. Thank you, CJ. Good afternoon, Judge Wendell.
Good afternoon.
Are you aware of the anti-sexual harassment policy?
I am.
Have you acquainted yourself with it?
I did.
Are you happy with it in its current form?
Yes, as I think it's the real test will come when there is actually a complaint, and we will see whether what is suggested by the policy, whether it works. But as I see it for the moment, I think everything has been covered. I'm part of the Education Committee in Johannesburg, and we are also planning a training session for our judges. I think one thing that is important is that everybody should subscribe to the policy. And I was thinking the other day how one would actually, with the many acting judges that we get in the Gauteng province, how would one go about establishing that as well. But I have acquainted myself, and I think it covers most of the most crucial aspects.
Thank you, Justice.
Thank you. Any more questions for Judge Wendell? No. All right, we have reached the end of your interview, Judge Wendell. Thank you very much for coming back, for your patience with us. I wish you all the best.
Thank you very much, Chief Justice. Thank you, Commissioners.